be seated.
We're in the courtroom. The time is 12:45. Mr. Wade is present as our counsel. Are we ready to proceed, Mr. Johnson? You're going to do the questioning? Ms. Morris is, okay. Mr. Mizrahi.
I want to point out that in reviewing the allocution of the line, I apologize to the prosecution for not cooperating initially. There's some cooperation. The state's request is that I apologize to the prosecution and state for not cooperating.
Maybe some merit to that, Mr. Johnson. Thank you, Mr. Mizrahi. May we otherwise proceed then? Okay, Mr. Wade's making some alterations, I think, to his document. So, all right, if the jury is ready, have them join us, please. All right, our jury has returned. Be seated, ladies and gentlemen. We remain in the defense's case. Ms. Morris. Ms. Gainey, if you'll come to the center to the clerk in front of me and take the oath, please. Please join me on the stand. Ms. Morris?
Sure, thank you. Could you please state your full name?
Frida Gainey,
Where do you currently live?
Jacksonville, Florida.
Are you Alan Wade's mother?
I am.
Did you grow up in Jacksonville?
Yes.
When did you move out of your family home?
When I was 19.
Did you do that to get married?
Yes.
And who did you marry?
Bob Craig.
Did you and Bob Craig have any children?
Robert, yes, one.
And how old was Robert when you and Bob eventually divorced?
About 2.
And after you and Bob divorced, where did you and Robert move to?
Daytona Beach.
And how did you meet Alan Wade Sr.?
I was a waitress at the time, and he was a patron of that restaurant.
And Did you and Al start dating in 1975?
It's about 75, yeah.
And when did you get married?
1980.
And how many children do you and Alan Sr. have?
2, Andrew and Alan.
And when was Andrew born?
1980.
And what were you doing for work during this time?
Mostly banking.
And what was Alan Sr. doing for work around the time that Andrew was born?
He had a mobile phone business. It's called AGS Communications.
And in 1986, did you and Alan Sr. purchase a home?
Yes, we did.
And where was that?
It was in Daytona Beach. Well, Daytona, not the beach.
Was that on Gibbon Street?
Yes.
Can you briefly tell us about that home?
It was, when we were looking at homes, I had requested that to the realtor, I want a 3-bedroom, 2-bath, screened-in back porch, and a fenced-in yard. And that is exactly what we got. It was the home I wanted.
And when was Alan Wade Jr. born?
He was born in 1987,
What month?
May.
And shortly after Alan's born, does Alan Sr. have some difficulties with his telecommunications business?
Yes, it kind of went out of business, and he started working in a sandwich shop.
Did that put financial strain on the family?
Yes, it did.
So what did you do around that time to help the family stay afloat?
I was still working in the bank. I was also making clothes for myself, business outfits, and a few little clothes for the boys. Just whatever I could do.
And how many days after Alan Jr. is born do you have to return back to work?
I was only out a week. Back then, we didn't get 6 months like they do today.
And who's watching Alan while you're working?
Either a babysitter or he was at the daycare.
And how old would Andrew and Robert have been around this time?
When Alan was born, Andrew was 7, and Robert was 8 years older, 15, 16. Can't do the math in my head.
And so what's going on in Andrew's life?
Andrew was has Asperger's, but he was not diagnosed until he was about 25. I was told he was a slow learner. He didn't start speaking until he was 3 years old, and he was very difficult to communicate with.
And after the telecommunications company that Alan Wade Sr. was working with went under, what else was he doing for work?
I believe he was just picking up scrap metal or something. I don't recall right off the top of my head. I know he had a sandwich shop.
And did you eventually leave First Florida Bank?
I did, yes.
And where did you start working after that?
I think I went over to the Savings and Loan, First National Savings and Loan.
Would Alan have been about 4 around this time?
Right.
Do you start attending a church in Daytona?
In Daytona, yes.
What church is that?
I don't remember the name of the church. I'm sorry.
This First Assembly of God?
First Assembly of God, yes, of Daytona.
And how often were you taking the boys to church?
We were there on Sundays, and they had events, usually Wednesday night. They had Wednesday classes, Sunday school classes, and they also had the Royal Rangers, which was like a boys club, Boy Scout thing, and they had events there, with the boys. So it was several times, I guess, a week, at least twice a week.
Did First Federal Savings and Loan eventually downsize?
Yes, and I lost my position there.
And what did you do to make ends meet after you lost your job?
I did quite a few odd jobs. One of them was trying to sell vacuum cleaners. I just started work in a repo business where they repossessed cars. Just whatever I could find at the time.
And around the time that you lose your job at First Federal, is that when Alan starts kindergarten?
Yes. Mm-hmm.
And as a result of you losing your job, excuse me, and Alan Wade Sr. working odd jobs, what happens to the family home on Gibbon Street?
It eventually went into foreclosure.
And where does the family move to?
I took the boys and went to, it's called the Water Club Apartments.
You said I took the boys. Did Alan Wade Sr. go with you?
No, we did not.
Did you separate?
Yes, we did.
Can you tell us a little bit about that?
Well, it was just all the financial struggle that we were going through, and problems with Andrew was so difficult to deal with, and the loss of jobs. It was just a lot of mostly financial stress on the family.
So you went from a 3-bedroom home on Gibbon Street. How many bedrooms did the apartment have at the Water Club?
2 small bedrooms.
And what was the area like at the apartment versus the area like at the home on Gibbon Street?
The home on Gibbon Street was a residential area. We lived in a cul-de-sac. It was a very nice neighborhood. The kids had friends there that they all went to school with. When we moved in the Water Club, it was down on the river, very low income. It wasn't a very nice neighborhood. But that was, at the time, it was all I could afford.
And was Robert living with the rest of the family at the Water Club?
No, Robert was, he had graduated by then, and he was on his own, and he did have an apartment in the Water Club also. So he was kind of there as a backup for me. But he was in the Water Club. I think he had 1 or 2 other roommates.
And were there children in the area of the apartment at the Water Club? Other children that your boys interacted with?
There were other children there, yes.
Can you tell us a little bit about that?
They were rough. There was a lot of them that had very little supervision. Of course, I was in the same situation with working, but they were just a bunch of mean kids. And one of them was like stealing toys from Alan. They liked to beat him up because he was a little kid on the block. And they made fun of Andrew, picked on him a lot because of his condition. It was rough on them.
So you mentioned that you and Alan Sr. are separated. So during this time, is he at least helping out with the children, maybe picking them up from school, things like that?
At that point, I did ask him to pick Alan up one day from school, and he didn't even know what school he went to, so it was hard. We did eventually reconcile temporarily at the Water Club. He came back and started trying to help out a little bit. At that time, we both had odd jobs at that point. There was nothing left in the banks were all merging. The savings and loans were going out of business. And it was really hard for me to get a situation somewhere.
While you were living at the Water Club, did you ever attempt to maybe take some types of classes to help with your career?
Yes, I found a class that it was for a paralegal, and they had classes at night, and I was going to try to do that and, try to, continue my education a little. I went for probably a week, and that was after Al had moved back in with us, but it seemed like it was inconvenient for him to watch the children while I was in these classes, so I had to stop that.
And while living at the Water Club apartments, does Alan begin grade school?
Yes, he does.
You and the boys lived at the Water Club for a total of how many years?
Around 1 year.
Does Alan complete 2nd grade?
Yes.
You mentioned that you and Al Sr. had a period where you were able to reconcile.
Mm-hmm.
Was there a point that came where the relationship finally ended?
It did, yes. I finally left. I took the boys and I moved I stayed with my sister for a while in McClinney, and we stayed there for about a month, and I found a job at a bank in McClinney, and I got set up in a trailer, and I got financial assistance from, you know, food stamps, rental assistance, every assistance I could get until I got on my feet.
So what was that breaking point for you when you knew that you had to take the boys and leave?
I was just totally depressed. I couldn't. Sorry. I couldn't take the pressure of not having an income, a steady income. I couldn't afford to buy clothes for the children. I couldn't hardly afford food at the time, and I was getting no assistance, no help from anywhere. And I was so depressed at that point, I said, something's got to break here because I can't do this. So I called my sister. She said, sure, I have room. Come on up, stay with me. We'll get you settled. And it only took me a month to go back to work in a bank in McClinney.
And when you left Daytona, would Alan have been around 8 years old?
Yes, he would be going into the 3rd grade.
Did Robert move with you and Alan and Andrew?
No, he stayed in Daytona.
And how long did y'all end up staying with your sister?
Just 1 month.
And you mentioned that you were able to get a place for you and the boys.
Yes, I found a trailer. I think it was like a Section 8 housing type thing. And I got the job in the Bank of McClinney.
Did you ever come to work for a company called Nivell?
Absolutely. I was at the Bank of McClinney for, it was almost a year. And they were merging, as all the banks were. And so I was last in, first out. So I came in contact through a friend, a company called Nivell. They were moving from Miami to Jacksonville. They were a golf cart company. They sold golf carts parts. I interviewed, got the job, and I worked with them for 24 years.
How long did it take you to commute to work to and from each day?
It was 40 to 45 minutes every day.
Did this result in you leaving earlier in the mornings and getting home later?
Yes, I left an hour early because you never know about traffic, and when I left there at 5 o'clock, it took me almost until 6 to get home.
And who was watching Alan after school until you could get home?
I made them call me as soon as they got home, and Andrew was responsible for what went on. For, you know, I left food, money for food, for like a pizza. They could walk over to the pizza place, or there was food in the refrigerator or something. I left a meal for them in case they got hungry before I got home. But it was Andrew's responsibility to keep an eye on his little brother, and he was supposed to call me. Now, Andrew was not capable of handling situations mentally because he was, well, he's about 45 now, and I don't know how to put it, he's like 15, an immature 15-year-old. He is living on his own now, but at that point, I told him he needed to call me in case something happened with Alan. They needed to stay at the house, don't leave the yard, and he had strict instructions to call me if something goes on, and he would do that.
In the summer of 1996, did divorce proceedings begin between you and Alan's father?
Yes.
You mentioned that you would take the boys to church in Daytona. Were you ever able to find a church family in McClinney?
Yes, we checked out several churches in the neighborhood before I signed up anywhere, and I wanted the boys to be happy wherever we went. They liked the First Assembly of God in McClinney because they had the Royal Ranger program. They liked the Royal Rangers. Like I said, it was like the Boy Scouts. They did camping, they did fishing, they did several outings, especially for the boys. So that's where we went.
Did Alan ever express to you his concerns about going to church there?
He always said he didn't want to go to church, but what 10-year-old boy wants to go to church? I never realized that he hated going to church. I thought it's just, I don't want to go to church, that kind of thing.
And during those early years of living in McClinney, when you were in the trailer, was Alan Sr. coming by to visit the boys?
He came by a few times, yes.
And do you recall when your divorce was finalized?
It was 93. I'm not sure the year. No, wait a minute. We moved up there in 95. I think it was 96.
And would Alan have been around 10 years old?
Yes,
Who got custody of Alan and Andrew in the divorce?
I did.
What about child support?
He was supposed to pay $250 a month plus take care of medical needs.
Did you regularly receive child support payments from Alan?
No, not regularly at all.
Did you face any financial hardships regarding your taxes?
Yes, while we were married, he took care of the finances, and I found out at some point that our income taxes had not been filed in 7 years. I had to go back and get all the forms from the IRS and all the forms that they could give me that they provided, the W-2s and what have you. And I sat there and filled out the income taxes for 7 years. I got that done in probably a week's time, after work and whatever. And yeah, I had to take care of that.
Do you and the boys eventually move out of the trailer on Long Drive?
We did. We only stayed there a year. And at that time, I was making enough money to finally able to purchase a home. I purchased a home in McClinney, and I was able to get a decent car, finally.
And was that on Long Drive?
I was on Long Drive, yes. That was a cul-de-sac, and yeah, it was a good neighborhood.
And was that move when Alan was roughly 11 years old?
Yes.
And where was Alan's room in that home?
He always had a room in the front of the house where the streetlights were because he was afraid of the dark.
And was the home on Long Drive in a subdivision?
Yes, it was a cul-de-sac. It was just a little subdivision there.
And was Alan able to make friends in the area?
Yeah, he always seemed to be able to make friends real easy. I mean, Alan was, he was he was a good little kid. Just as sweet as he could be. He was very helpful. I always called him my retirement plan because he was intelligent and he seemed ambitious and very talented with his basketball and skating and skateboarding and whatever he did. He was good at it, and I thought, well, here's my retirement plan. So he was a good kid.
From your observations, did Alan tend to hang out with kids in the neighborhood that were of his age or older?
He always tended to go with older kids, and I assume that was because he was used to having older brothers. So that was my perception of why he went with older children.
And after the move to the home on Long Drive, is Alan Sr., does he offer to come get the boys for the summer?
He did one summer. I think it was the first year we lived in the house. He said he'd take Andrew for a month, and then he'd take Alan for a month. We got Andrew, and that lasted a week. Again, Andrew's really hard to deal with. You have to know how to handle him. So that lasted a week, and then he never did take Alan for his turn.
And how did that make Alan feel?
Alan was crushed. That's when Alan started getting mad at me because I took his dad away. He hated me for that.
And during that summer, the summer that he was 11, did he go to visit any family?
Yes, he went to visit his older brother, Robert.
And after he returns that summer, does he begin middle school?
Yes,
And where was that?
in McClenny.
And how does Alan do in 6th grade?
He doesn't do well at all. He was mad at me, mad at his father, and he just did not want to study. Up until that point, he was an excellent student, making straight A's. But once all this divorce and change and his dad not showing up, once all that started, he just wasn't functioning well.
Does he pass 6th grade?
No, not at all.
And how does Alan react to this? How does that make him feel?
Well, he's upset now because now he's behind all of his classmates, and that, I think, made him feel stupid, which was far from the truth because, like I said, he's very intelligent. He could do math work. He could do division and math problems in his head. And he just amazed me with his math abilities.
And after he is not able to successfully complete the 6th grade, do you attempt to homeschool Alan?
I tried. Again, I was working all day. I didn't get home till 6 o'clock. I had Andrew's problems to deal with because he had problems in school. I had to regulate him every quarter, this class, then that class, and this class, and keep him in line in school. And so I trusted Alan to do the work I knew he could do, but he wasn't making an effort.
And while you were working in Jacksonville during the day, were you able to supervise Alan's schoolwork in any way?
No.
I want to jump very quickly over to Andrew. When does he graduate high school?
In 2000.
And does Al Sr. show up to the graduation?
Yes, he did.
Do you and the boys see him again after that graduation?
Not that I recall.
Was that hard for Alan?
Of course it was.
Did he understand?
No, I don't think he ever understood. He never got over me leaving his dad. He never got over his dad leaving him.
Was he 13 at that time?
About 13, yes, sir.
Ms. Gainey, did you try to reach out to Alan Sr.?
I did. He had left his phone number at one point. I tried the phone number. It did work a couple of times. Honestly, I never told him he could not see the children. Anytime you wanted to come to the house, come. Anytime you wanted to call, this is the phone number. I gave him every opportunity because I knew how much the children needed him. Those two boys needed him. And I made every effort to well, I couldn't keep in touch with him. I didn't know what his phone number was at some point. I didn't know where he lived at some points. But he had my number, and he knew where I lived.
And was it around this time that you first learned that Alan was using marijuana?
Yes.
And how did you learn about that?
Well, I came home one day, and there was marijuana smell in the garage.
Did you talk to Andrew about it?
Andrew called me after I realized, I don't think Andrew realized what was going on in the garage. But I told Andrew, I said, this is what this smells like. If you smell this or those kids come over to the house and you see them smoking in the garage, I need to know. And at one point, he even called the police on them.
When did you and Mr. Jerry Gainey start dating?
It's in 2000.
Did Mr. Gainey live in Jacksonville?
Yes, he did.
Were you traveling to see him?
Sporadically, yes. We didn't see each other that much.
Did Jerry have any interest in getting married or helping raise your two boys?
No, he was just a friend, somebody to talk to, lean on at that point.
Now, in April of 2001, when Alan's 13, does something significant happen in your life?
Yes, I was diagnosed with breast cancer.
Before we get too deep into your cancer and the treatments that you received, I want to talk to you about Alan's demeanor and character before the age of 13. Can you talk to us about that?
Like I said, he was a wonderful little kid. I mean, you know, he's the kind of kid that brought home stray kittens. He did that once, and I told him, we have a dog, we can't have a cat. So, you know, and I used to work in the yard a lot before the cancer treatments. I can't take heat now, but I used to do a lot of yard work, and he would get out there and help me, you know, plant the flowers. He would help me, you know, whatever I needed, cut the grass, whatever. He was just a sweet kid. He was very helpful. I even caught him cooking one morning. He was flipping eggs on the grill. He was a trip. He was just the cutest little kid you'd ever want.
You testified that his dad has left and now you've been diagnosed with cancer. Did you see a change in him around that age?
Yeah. Well, he actually started changing a couple years before that. Like I said, he was angry about the divorce. He was angry about his dad. But it took a little sharper turn when I was diagnosed. And he was already getting to the point where he was hard to handle. And now I've got cancer, and I'm still dealing with Andrew. Yeah, I had a full plate.
The day after Alan's 14th birthday, did you have a major surgery?
Yes.
And what was that?
That was a mastectomy.
Was that the only surgery that you had in relation to your cancer diagnosis?
I had reconstruction surgery. I also had it was a tram flap. I don't need to go into all that, but that herniated a couple of times over the year. I had to go back in for that. So I was in and out of the hospital several times in a year and a half.
And that summer, did you begin chemotherapy?
Actually, yes, it was the end of 2001. I think it was in September, October, I started chemo treatments.
And how often were you receiving chemotherapy treatments?
I think it was on Friday every other week, and there were 4 treatments to the best of my memory.
And were your doctors there close to you in McClinney, or were they in Jacksonville?
In Jacksonville. I went to the St. Vincent's Hospital.
Along with your cancer medications, what other medications were you taking?
They had me on Zoloft for anxiety. The tamoxifen was the cancer medication, so tamoxifen and Zoloft.
And did you develop any cognitive difficulties because of your cancer treatment?
Absolutely. I had never taken an antidepressant in my life, and usually if I take a couple baby aspirins, it makes me groggy. So between the Zoloft and the tamoxifen, I could barely function. They demoted me at my job. I was working in accounts receivable. They put me on answering the phone and sorting the mail, which is just about all I could do at the time. And I had trouble driving back and forth to work. I think my husband said that they used to have a rest stop, and every once in a while on the way to work and sometimes on the way home I'd have to stop and just rest. Sometimes I fell asleep and then go on back home.
Were there any other side effects that you had from your cancer treatments? Such as losing your hair or becoming...
Yeah, I lost all my hair and yeah, it was very hard. I had a couple of wigs I had to wear for a year.
Did you take any time off from work after your initial surgeries and treatments?
They told me I could take family leave time. I took as much as I felt I needed, but because they had already demoted me, I felt like I needed to keep my job. That was the only income we had, was my job. So I had to keep working. So I was afraid to take off too much time. Because you don't know. I mean, the boss said, well, I'm not going to fire you, but they can say I'm not going to fire you today and tomorrow you're gone. So
you have a lot going on with your surgeries and your treatments, trying to work. So Who was watching Alan during all of this time?
Andrew was responsible for keeping an eye on me and calling him. I couldn't afford a babysitter. I had no family close. My sister was there, but she has 6 kids. She's got her own situation, and she lived way out in the country. No, and so Andrew was just responsible for calling me whenever he thought there was a problem.
Did you reach out to members of the community to help with Alan?
I asked some of the men at church if they could, kind of step up and act like, take him fishing, take him hunting, spend time with him, take him out for a burger, talk to him, counsel him a little bit. And the people at church say, anytime you need help, anytime you need anything, call. And that sometimes does not work.
Does Alan start getting in trouble around this time?
Yes, he does.
Ms. Gainey, what did you tell Alan about what caused your cancer?
I didn't remember this conversation for the longest time. Alan recently reminded me that I told him that the cancer was his fault because he was causing me so much stress all the time, getting into trouble, and he needed to stop causing trouble because I had enough on my plate with Andrew, and I was counting on him to be my helper.
That summer, do you decide to send Alan to visit with family up north?
Yes.
And who does he go and visit?
He went to visit Trish.
And when Alan returns from visiting with Trish, does he start 7th grade?
Yes, I believe so.
And does he pass 7th grade?
No, he failed 7th grade.
And during this time that you're struggling through all of these treatments, are you receiving any child support payments?
No, maybe one every 4 or 5 months.
In the fall of 2002, does Alan begin 8th grade?
Yes.
Do you receive a call from Baker County Middle School that year with some concerns about Alan?
He had missed so much school, even though I was dropping him off in the morning, that I either had to withdraw him from school or I was going to end up in jail. That's what they told me. So I withdrew him from school in the 8th grade.
Before you withdrew him, did Baker County Middle School call you regarding Alan attempting to commit suicide?
Yes, that was another call. I got the call at work. They said he had said he was going to commit suicide. I drove out there immediately, and I talked to one of the counselors or a teacher or somebody, and the police were there. They were chasing him through the neighborhood because he had left the school grounds. And when they finally found him, they Baker acted him.
Would he have been around 15 at this time?
Yes.
We talked about your surgeries and your chemotherapy. Did you ever have radiation treatment?
I did in January 2002. I took the radiation in 28 treatments. I drove from work on my lunch hour down from, my job was close to the airport out that way, and I drove to St. Vincent's Hospital and back on my lunch hour to have radiation treatments during the week for 28 days.
In the spring of 2003, Alan's still 15. Do you kick him out?
I know he thinks I didn't love him. I tried. I mean, I love him. He doesn't understand that I depended on him to be the strong one, and that was wrong of me. I threatened to kick him out never dreaming that he would go. I was thinking, okay, I threatened to kick him out. He's going to say, I'm sorry, Mommy, I'm sorry, I'll behave. I did not want him to leave, but he did.
Do you know where he went?
He went to Teresa Roden's house.
Did you eventually go get Alan from Teresa Roden?
Yes, I did.
Can you tell us a little bit about that?
She said he could stay there. I don't remember how long he had been there at that point. She said he could stay, but she was going to have some financial support to keep him. I was embarrassed and hurt to think that I'm going to have to pay somebody to take care of my own child because I'm not capable. That kind of crushed me. What kind of mother am I that I can't take care of my own child? That I have to pay this woman so that he'd have a decent place to live? It crushed me. I couldn't do it. I had to take him. He's my baby. So I took him home.
You mentioned that you withdrew Alan from school because you were possibly facing legal sanctions.
That's what the school told me, yes.
And what did you do about that?
Well, I took him home. I withdrew him, and I believe that's when we started the homeschooling. 8th grade, I don't remember.
Is Alan eventually enrolled in Baker County High School?
Yes.
Does he successfully start high school?
He seemed like he was doing okay.
Did he eventually become not okay?
Yes.
Tell us a little bit about GED classes.
Okay. He was no longer in school at this point. So I said, all right, well, you're going to get your GED. So they offered it at Baker County High School. So, and they had it at night. So when I came home from work, I would get him, take him to the high school, and make sure that he was in classes. And I would have to sit outside the door to make sure that he didn't run away, because he needed to complete his GED. So I sat there for the hour or however long it was to make sure that he stayed in the class. And he did complete the GED.
Now, around the age of 16, is Alan's drug use becoming more of a problem?
Yes, around that age. And I still didn't have half a brain because I was still on the medication. So I decided I needed to, Andrew was gone. He got married. He moved to Georgia. So I decided to sell the house because I couldn't keep up with keeping the bills paid. Not that I couldn't afford it, I just couldn't remember to pay them. So I found an apartment close to work in Jacksonville, so I would have my doctor, it was between St. Vincent's and my work. And I thought that would make it easier on me, get Alan away from the bad influence of McClinney, because at that point he was really into drugs, and I was finally aware of this. And I thought if I get him away from this group and get him over here and try to get him in another school or get him a job or something, things would be better. So we moved into the University Club Boulevard in Arlington.
Ms. Kinney, do you know Bruce Nixon?
Yes, I do.
And how do you know him?
He was a school friend of Alan's that used to come over to the house when he had family problems. And I kind of felt sorry for the boy because I didn't feel like he was as sharp as Alan. And I felt like he needed a little more help. I guess I felt that way because of taking care of Andrew so much. I felt like, well, Bruce seems like he needs special attention also. I never felt that way about Alan because he was so smart. Anyway, I took him in and I kind of babied him, and I said, make sure you call your mom, tell her where you're at, and, just, fed him. And
Did you continue to communicate with Bruce even after the arrest?
yes,
Did you communicate with him over the phone when he was in custody?
when he was in custody, no, I actually visited him in jail.
Okay. And did you exchange any letters?
Yes,
Did you receive a letter from Bruce in July of 2008?
I did.
Ms. Gandy, I want to turn your attention to the document that is in front of you at the witness stand, which has been pre-marked as a Defense Exhibit A for identification. Do you recognize that document?
I do.
And are you familiar with Mr. Nixon's handwriting?
Yes,
Is the content of that letter consistent with things that you and Bruce would typically discuss?
well, after he was arrested, we really didn't talk about specifics, but yes, this is generally what we had discussed.
And when you received that letter, did it come postmarked from a detention facility?
Yes,
Okay, and does the letter that is in front of you, does that appear to be the same letter that you received from Bruce in July of 2008?
yes.
Your Honor, at this time, I would offer into evidence what has been pre-marked as Defense Exhibit A as Defense Exhibit 6.
Ms. Mizrahi? All right, it'll be appropriately marked.
Thank you, Your Honor. You mentioned that you moved to Arlington Apartments, is that correct?
All right. Mhm.
Okay. And would Alan have been around 16?
Yes. Mm-hmm.
Did Alan Sr. ever visit the boys after moving to Jacksonville?
No, no.
Are you getting child support checks yet?
No.
In the fall of 2004, does Alan meet Michael Jackson?
Yes,
Do you also meet Michael Jackson?
I did.
Were you aware that Michael was 5 years older than Alan?
Yes, he told me that.
Did you get the impression that Alan looked up to Michael?
At first, yeah. And Michael seemed to be an intelligent kind of guy, friendly when I first met him, just talkative and just kind of on the showy side, like he had a big personality. He was very confident. And I thought, well, he's a little cocky, but, he's a boy.
Were there any interactions between you and Michael Jackson at the Arlington Apartments?
Yeah, oh, yeah.
Can you tell us about that?
One in particular, it was in the parking lot. This is after I had learned about Michael's real personality. I was driving through the parking lot coming home, and I saw him sitting there on the back of a car. And I said, Michael, do you know where Alan's at? And he proceeded to tell me that that was none of my business. He was taking care of Alan, and I just leave Alan alone. He's my concern now. And I said, is that a stolen car you're sitting on? And he got right up in my face in the window and threatened me that you just stay out of my business and just go on if you don't want anything to happen to Alan. I'm paraphrasing, of course, but there was a threat.
Would Michael ever randomly call Alan and tell him that he was coming to pick him up?
Yes,
Did you let him go?
he had to go. That's what he told me. I have to go, Mom. I have to go.
And what emotions are you seeing from Alan around this time?
He's nervous. I realized he was probably drinking and probably taking drugs. And, with me working, I can't control him now. He's got all day. He worked for a couple of weeks at a Steak and Shake. That only lasted a week or two. But I'm at work. I can't, I have to work. And you can tell a kid to sit there all day and behave. But he was with Michael, and I had very little influence over him at that time.
In the winter of 2005, when Alan is 17, does he attempt to join the Army National Guard?
He did. As a matter of fact, Sergeant Wilcox actually came to my apartment and spoke to me. And he actually mentioned Michael. And he said, this Michael guy is a bad influence. Alan needs to get away from him. And we want to get him in the Army. He said, I'll work with him, do what I can to get him in the Army. And I was so appreciative. I think he actually came to the apartment twice to talk to Alan. And he just never could get a clean drug test.
Do you move out of the Arlington apartments in 2005?
Yes.
Did you allow Alan to move to your new apartment with you?
I was having a lot of medical problems. And I had friends and family, about everybody I knew, told me you can't keep up with the stress that he's causing you because it's making you sick. I was physically exhausted. I was still on that Zoloft. My coworkers were telling me that I looked like a zombie because my eyes were glassed over most of the time because of these drugs. And everybody told me you need to just let him go. And I felt like I didn't have a choice. It's the worst decision I ever made in my life, and I regret it till the day I die. But I had to go. Like I said, my friends and my family just, you're doing this. You're doing this. They took over for me, and they moved me out, and we found an apartment. Go ahead.
Oh, no, please continue.
Well, after I moved, I told Alan, I said, you're on your own. But he knew my number, and over the next month he called, and I went and got him, and I took him back to my new apartment, and I fed him, and he spent the night, and we started making plans to move. This was a one-bedroom. We started making plans to move in a two-bedroom together. And we actually went and looked at a two-bedroom apartment together. And I said, please come back and live with me. I want to take care of you. And he said, okay. And I had told him, I said, I don't want Michael to know where I'm at, because I was afraid of Michael because of, he threatened me, and I was afraid if I got in the middle of something, he would harm Alan. And so Alan and I spent some time together, and like I said, we looked at an apartment, and then he'd go back over there to Michael. And this went on for a couple of months, and finally Michael showed up at my door, and he said, I'm sorry, Mom, Michael forced me to tell him where you live. And Michael came to my apartment, and I just exploded on him. I just went off on this boy. And he sat there and looked me stone-faced in the eye the whole time I was yelling at him, with this stupid smirk on his face. He had no regard for my feelings, for Alan's feelings, for anybody. And he finally just, when I finally stopped, he got up and just said, I don't care what you think. And he walked away.
At the time of Alan's arrest in 2005, are you still taking prescribed cancer medication?
I am, yes. They had me on that for 4 years of Zoloft and tamoxifen.
How did you find out about Alan's arrest?
TV. I saw Bruce Nixon on TV. And then my sister called Jerry, and Jerry came over to the apartment to be with me because I knew something was going on, because I had seen Bruce with Michael and Tiffany prior to that. At some point, he showed up at my apartment with Michael and Tiffany. So the four of them were together at some point.
And what state was Alan arrested in?
South Carolina.
Did you drive to South Carolina to see him?
I did. I went twice.
And when Alan was transported here to Duval County Jail, did you visit him?
Every time they let me.
And were you putting money in Alan's account?
I absolutely was.
Did you send him anything?
Books. By the truckloads, 2 a week.
2 a week for how many years?
Probably 3 years, the whole time he was there.
And what kind of books were you sending?
He wanted the classics. He started out with Steinbeck and Hemingway and, a few of those. And, of course, I had to send all of Hemingway's, all of Steinbeck, and all of, whatever he wanted. And then he gets into the Machiavelli. I didn't even know what that was, so he wanted that one. Then he gets into physics, and then he gets into psychology, and then he gets into these math books, and there were a lot of them I didn't even know what they were. So he gave me the title, and I'd ordered it.
Your Honor, may I approach the witness? Ms. Beatty, I'm showing you what's been labeled as Defense Exhibit 3. Can you please describe what you're holding in your hand for the jury?
Yes, this is a list of books that I actually went back on the Amazon history on my computer to see the books I had ordered off Amazon. And there was another bookstore I used to order from also. I think it was called Thrift Bookstore, and that wasn't on my Amazon history. But this is just what I got from Amazon.
And how many years worth of books have you included on this?
From 2006 to 2016.
Ms. Gainey, there was a letter that was in front of you a few moments ago that we discussed from Bruce Nixon, correct? Mm-hmm. You've had an opportunity to review that letter?
Just barely. I read over it while I was here.
But you've seen that letter before?
Yes,
Okay. Now, the jury's going to have that letter sent back with them, but generally, is it Bruce apologizing for going along with what the state told him to do?
He did. He said he was very sorry that he had lied about Alan, and he's sorry that he went along with what the state told him to say.
Did Alan obtain his GED while he was in jail?
He did. Mm-hmm.
Have you been present for all of Alan's court proceedings over the years?
I have.
And after Alan was sent to prison, did you continue to visit with him?
I did. Mm-hmm.
Do you still visit with him?
I do, every Sunday.
Do you talk on the phone?
Yes,
Do you put money on his account?
every other week.
When Alan got to prison, did you call and ask them about the lights?
Yeah, I called the prison and I said, I need to know if you have lights in the hallway on at night because my son's afraid of the dark.
Have you seen a change in Alan since his arrest in 2005?
Absolutely, I have.
Tell us about that.
He has grown up into a wonderful man. I mean, we talk over the years. We have, we play cards during the visits. We talk about, I never wanted to talk about the case. Never. not even in person, because that's not who I see my son as. That's not who Alan is. We talk about family, we talk about, cheating at cards. We just talk, and we're friendly, and we get along. I love him to death. He's my baby. And he's just a precious man. He's helpful to other people. I've heard other inmates say that Alan's a positive influence on them. Several guys, and when we're in the visitation, he seems to have a lot of friends, and he's very respected among the inmates.
Ms. Gainey, will you continue to love and support Alan if he spends the rest of his life in prison?
Absolutely.
Your Honor, may I have just one more moment?
Sure.
Good afternoon, Ms. Gainey.
Hi.
A couple things I just want to clear up for the record. Ms. Gainey, when you withdrew your son from school, he was 16 years old.
Approximately.
Well, I think he has to be 16
Okay,
before
yeah.
he gets withdrawn. Is that correct?
Yes. Mm-hmm.
So even though we were talking about ninth grade, he was still 16, and that's because of the prior non-completions of grades.
Yes.
From all the times that you saw or suspected your son of doing drugs or drinking, you never saw violence out of him, correct?
I never saw what?
Violence out of your son.
He would get mad, but he would never act out on it. I mean, people get mad, but they don't punch the walls or kick the dog or anything. No, I never saw him get violent.
Okay. And I think there's, in one of the paperworks with regard to his commitment, when he was having drug problems, you indicated that sometimes that he would get so angry at you that you would just back out. You remember saying that?
Yeah, I remember him getting angry. He would just walk away.
I think you said you walked away. Either way, I
Well,
think it's
either
similar
way,
to what you're
yeah,
doing.
we never got into a conflict.
Now, as a result of this commitment, you scheduled appointments for your son to get further treatment once he was discharged, correct?
Right,
And you tried to get him to go to these appointments, correct?
yes.
And he went to one of the appointments,
He went to one,
but you couldn't make him go to any more.
correct,
And you tried to make sure that he got the therapy he needed.
correct.
Did the best you could.
Mm-hmm.
But yes.
Yes,
Okay. And I think it's obvious, but I just want to point out for the record, obviously you couldn't physically control your son, correct?
correct,
He was bigger than you, stronger than you, all those things, correct?
correct.
In fact, although I hear your testimony about Michael Jackson, he was bigger and stronger than Michael Jackson, correct?
They were about the same size.
Well,
if
at
I
the time of
remember
the
correctly.
crime, your son, maybe not in the very beginning when you met, your son was, you kept growing, and so by the time they committed the crime, he was taller,
Yeah,
probably
Yes.
bigger.
yes.
When Mr. Wade was arrested, you, how do I put this delicately? You called the Jacksonville Sheriff's Office a lot. Is that fair?
I
First
don't-
couple days after his arrest.
Probably looking for him.
Right. I'm not saying there's anything wrong with it, but you would call, I think it was Detective Gupton, over and over again, leaving messages. I think you even said one time you may have cussed him out and you were worried they were going to come get you. Remember any of that stuff?
And I vaguely remember talking, calling and looking for him. I don't remember conversations, I'm sorry.
That's fine. The details of it are not important. The important thing is that you were kind of like a mama bear trying to find her cub. Is that
Right,
fair?
right, mm-hmm.
And you had a very close relationship with Bruce Nixon.
I wouldn't say close. I mean, he did call me mama. I just felt bad for him. I didn't feel like he was my son. I just felt sorry for him more than anything.
And that's fair. You kept apprised of what he was doing in his case, correct?
Exactly, yes,
You saw the trial with regard to your son, correct?
yes,
You were here, watching the whole thing, correct?
Yes.
When Bruce Nixon was sentenced, were you present?
I don't think I was present when Bruce testified, for whatever reason.
Were you aware of the fact that prior to Bruce Nixon being sentenced, that he had what they refer to as an allocution with the Sumner family? Were you aware of that?
No.
And so, did you ever hear that Bruce apologized to the family or anything like that?
Okay, yes, I'm sorry. I vaguely remember that, yes.
Because I think we talked about it.
Okay.
And so you knew that that had taken place before he was sentenced.
I think so, yes.
So the letter you got from Mr. Nixon took place after he was sentenced in prison, correct?
Right. Mm-hmm.
And he told you these things about how the state manipulated him.
Right.
But he also asked you to send him money, right?
He did ask for money. I may have given him a little bit, but not much, because I was giving money to Alan.
No, but in the letter he asked for it. You want to see the letter again?
I don't have it anymore.
May I approach you on? It's a drawing at the bottom. You can read the whole thing.
Oh, okay. Keep praying. Yeah, let me see. Oh, I'm sorry, I don't have my glasses on. Please send money, yeah. I may or may not have sent him money.
Okay. And
I don't remember. Like I said, I was financing Alan, so.
Sure, I understand. Whether you send him money is not important, but in the letter it says, P.S., please send some money.
Yeah.
There's one last point I need to make, and that is your family was pushing you to make this decision, which I call, correct me if I'm wrong, tough love that you were giving to Alan.
That's what they were telling me. This is tough love. You got to let him go because he's ruining your health. Yes.
But I want to be clear, this wasn't out of the blue. There was instance after instance after instance of Alan Wade doing things that were bad for him and you, correct?
Correct.
Criminal acts, yes?
Yes.
Stealing from you,
Yes.
disobeying your rules,
Yes.
and at some point you felt there had to be consequences to his actions.
Correct.
And I agree. I understand that you regret the decision you made, but that was why you made the decision.
Correct.
That's all the questions I have.
For the record, Lawrence? Members of the jury, questions for Ms. Gaines? I see one or two hands raised. Bear with me just a moment. Ms. Gainey, I'm going to ask you a couple of questions from the jury. Please give them the answers. Don't tell me. And there is no particular order or sequence to any of these, so it may be a little bit disjointed, but try and answer. Did you ever apologize for Alan to not being there for him?
I'm sure I did over the last 15 years that he's been in prison. I'm sure I've apologized several times. I don't know that it was, my memory is so bad. I apologize with the drugs. There are some years I have no recollection of because of the Zoloft and the tamoxifen, but yes, I'm sure I have.
Mm-hmm. You made him go to GED classes and waited for him for almost an hour and a half. Why were you not able to take him and ensure that he attended further treatment?
His treatments were in the evening. When I got back from work, I was driving from Jacksonville to McClinney. The problem was when I got home, he wasn't there. If I can't find him, I can't take him to treatment. So that was my problem. I couldn't find him.
Did you and Alan's father model empathy and understanding with him?
Sorry, say that again?
Did you and Alan's father model empathy? Were you empathetic and understanding to him?
I would say yes. Like I said, after the divorce, he was mad at both of us. And we dealt with that the best way you can with small children. I mean, he was about 6, 7 when we divorced. And you try to comfort him. And when his father leaves, I do the best I can to, be there for him. I think that answers the question.
All right. Next one is, why didn't you agree to let the Rodens take Alan in?
Well, like I said, I felt embarrassed and ashamed because I couldn't take care of my own child. To pay another woman, to have him live at her home, to let her be the mother instead of me, it just upset me that I don't want my baby being raised by somebody else, even though I probably knew deep down that I wasn't doing a good job, but he's still my baby. He's still mine, and it was hurtful to think that I had to pay somebody to take care of him.
Well, Ms. Gainey, were you aware of the incident at the church in Daytona, and if so, what was your response?
I had no idea what happened at Daytona. I was not aware of it until just the last couple of weeks. I had no inkling, no clue.
What do you believe caused Mr. Wade to participate in this crime?
Michael Jackson and the drugs. He found somebody that he thought he could trust. He found somebody that he could get the drugs from. He was so hooked on the drugs that he needed, and he looked up to Michael. And like I said, when I first met him, he acted like, he's a big shot, he's cool. And Alan saw that in him at first, and of course once he got attached to him and Michael started giving him money, giving him drugs, Michael controlled him. And I don't think he felt like he had a way to not participate without Michael hurting him in some way.
If you understand what this is in reference to, Ms. Gainey, why did you change the locks when he left or was put out?
At the apartment? At where?
It may be that you can't answer the question. I don't know.
I don't remember changing any locks.
Okay.
I really don't. I'm sorry.
Were you concerned about letting Alan stay with Robert, knowing that Robert used drugs?
Well, Robert was his brother, and I knew he was probably better off with a couple, with Nikki and Robert together, than he was with me by myself after the surgery, because I was bedridden for a couple of weeks, and all the surgeries that followed it, I figured Robert would have more influence and control over him for the time that he was there than I could provide.
All right, follow-ups, Ms. Morris? Mr. and Ms. Rahi?
Not mistake.
Ms. Gainey, thanks for your time. You may step down. Yes, ladies and gentlemen, why don't you step back into the jury room for just a few moments, please. All right, the jury has
This is it, man. About 17 years overdue, so we gotta do it. I'll see you. Yes, sir.
Mr. Wade, you now had another hour and a half or so to consider our conversation earlier. Are you still prepared to do this?
Yes, sir.
You still understand the risks?
Yes, sir.
Is that enough time to go through this? In order to
Yes, sir.
Just give me any explanation.
Well, that's, I was really just about to ask. I thought that I would say that Mr. Wade was asked for the opportunity to read a statement to the jury.
And you said, what's next defense? I was going to say, we'd like to present the allocution of Alan Wade. Or said it's
The only thing I'm thinking about, again, talking out loud, should some information given to the jury, not that I didn't have any questions, but out loud.
Should say, this is an unsworn statement, not subject to cross-examination.
I'm not satisfied. You said the jury needs to know.
Mr. Wade has asked for the opportunity to give you an unsworn statement or
Not subject to
why, or
I like that. And I would say, Your Honor, we now ask for the opportunity to present the allocution of Alan Wade, and you would say, Mr. Wade is going to read a prepared statement, it's an unprepared, unsworn statement, it's not subject to cross-examination.
that work for you then? Okay.
I'm not as well trained as my, Jack from the back.
Thank you, because somebody else probably does need to look at this. All right, we are in the courtroom. Mr. Wade is on the stand. If the jury is ready, have them join us, please. And I am going to want input from counsel about what I'm going to tell them during the final charges about how to weigh this, or not, or whatever. So, okay. All right, the jury has returned. Be seated, ladies and gentlemen. All right, members of the panel, this is an unsworn statement by Mr. Wade that is not subject to cross-examination. Mr. Wade.
Thank you.
Before you start, if you could please tell us your name,
Alan Wade,
what is your date of birth?
5/22/87.
Did you prepare a statement to the Sumner family, whose jury that you'd like to read?
Yes, ma'am. Nothing I say here today is meant to justify, excuse, or defend my cowardly crimes. Reggie and Carol, if there's a window or a connection to the afterlife or some sort of cosmic consciousness. And I know you can see the tremendous regret and shame in my heart. Every day I'm tormented by my cruel and careless actions against you. I should have helped instead of hurted you. I'm forever sorry for my senseless, unprovoked, undeserved actions against you. This is the most passionate regret and the biggest mistake of my life. I'm also sorry for the pain and loss I've caused the Sumner's family and friends. I'm sorry for the dishonor and disrespect I've shown to both their families and my own. And to both of these families, my apologies are without end. I'd like to thank the judge in this court for allowing me this opportunity. I apologize to the prosecution and the state for not being more cooperative. Also to the Sumner's family, this apology is long overdue. I'm sorry to the jurors for any trouble and inconvenience for you being here. I'm sorry you have to be exposed to the horrific things that I've done. When I was 20 years old, I arrived at prison. I turned 21 a couple months after, and for about a year, I couldn't stand to look at the man in the mirror. I was disgusted with the sight of myself, and I'd felt this way for some years before. But I really wanted him gone. I contemplated suicide on several occasions before finally accepted my fate. At some point around 22 or 23, I tore myself down, everything I thought I knew, and I rebuilt myself and the views in my life views, and I started to develop a morality that fit me. I decided I'd spend the rest of my time alive, learning and doing as much good as possible, whether it be encouraging a neighbor or showing love to someone I care about. Around the same time, I immersed myself in philosophy, and I came out with a more realistic, better understanding, better sense of being in humanism. Since my early 20s, my time has been largely focused on education, skill building, and expanding my social circles. Philosophy has opened my mind to different ways of thinking. Had somebody not sent me a book about Socrates when I first got to prison, I believe my experience in prison would have been far less productive. Science has kept me grounded. It's been a baseline for whenever things get too complicated. So quite often, I learned more ways to use the scientific application to make our lives better and more clear from a book by Michael Shermer called The Moral Art. When things are clear, they're less subject to manipulation and exploitation. So naturally, I'm drawn to this. Communication was always something that I struggled to grasp very well. So I put a lot of time and effort into developing my lexicon and being social regularly. Trying to learn other languages has given me a better understanding and appreciation for English, which is awesome. These social skills have been vital for repairing some of the family relationships that I destroyed and forging new bonds into ultimately the imperfect, perfect group we are today. I want to make them proud, and in their own way, I'm sure they all are. This is the compass needle that points me in the direction I want to travel in my life. I can promise that the person capable of doing these things no longer exists. I'm finally on the path to being the man that I always wanted to be. I've decided to, I've dedicated my life to being virtuous, devoted, and loving. Again, none of this is meant to justify or defend my inexcusable crimes. I wholeheartedly wish there was something I could do or say to heal all the hearts I've broken, to ease the animus, and to undo my gross violations against humanity. That's all.
Members of the jury, why don't you step back on the jury for just a moment, please? All right, the jury has left the courtroom. Go ahead and stand down, Mr. Wade. And I presume the defense rests? Sure. Go ahead and be seated, ladies and gentlemen. I'm sorry, what?
Statements after the presence outside of the jury regarding his testimony, removing prior to the.
I'm sorry, stop.
Prior to this testimony. Here now, asking here, I'm now asking the court to again allow us to use his statements on the stand.
Oh, from when he was here last week? Oh. No. Question tonight. The record is what it is, Mr. Johnson. I don't think you need to proffer anything further on it. I mean, it was all under oath and on the stand, so. But that request is denied. That said, does the defense also rest? If the jury's ready, have them join us, please. I assume Detective Meacham is ready to go, or?
Yeah.
The jury's ready, have them join us, please.
Enter the courtroom.
All right, the jury's returned. The jury's back in the courtroom. Please be seated, ladies and gentlemen. Defense is rested. Mr. Mizrahi.
I say as a brief rebuttal with Special Agent Dave Beecham.
Agent, if you please, well, I will remind you, you're still under oath, so just if you'll just resume the stand. Mizrahi.
Thank you, Your Honor. Agent Meacham, I want to turn your attention to the arrest of Alan Wade in North Charleston. When you first met Mr. Wade, did he appear to be under the influence of drugs or alcohol?
No, sir, he did not.
And are you trained as a law enforcement officer to be able to recognize those things?
We are.
And did you notice anything?
I did not.
What time of the day or night was your first interview with the defendant?
I believe the first contact was very late afternoon, early evening, and several hours from that point until probably midnight. On different occasions, I spoke with him.
During the course of your interview, late into the night with the defendant, did you attempt to get the defendant to talk to you about the facts and circumstances surrounding the Sumner's disappearance?
Yes, I did.
Are you trained in how to do that?
Yes,
Did you have a partner with you?
I did.
Who was that partner?
Mark Gupton.
Is he trained?
He is.
Did both of y'all attempt to elicit information from the defendant?
Yes, we did.
Did you do your best?
Yes, I did.
Use every tactic in the book, so to speak?
I did.
And did Mr. Wade ever provide you any information with regard to this matter?
No, he did not.
Subsequent to your interview, did you have the occasion to obtain a jail telephone call between Alan Wade and Frida Gainey either 1 or 2 days after his arrest?
Yes, we did.
And have you listened to that?
I have.
And does that conversation fairly and accurately depict Mr. Wade and Ms. Gainey talking about the arrest that you just participated in North Charleston?
Yes.
This time, and you've listened to it.
Yes.
At this time, I would move into evidence 7N as its pre-marked exhibit.
If we could object to the subject of the motion to be about comment approach.
Based on what I have heard to this point, the motion eliminated the those rules or whatever. I mean, you did make the argument. I understand what the objection is. I told you I was waiting on here. Motion eliminated the mark.
States Exhibit 175, Mail College.
Please.
Please collect call. The cost of this call is $5.88 for the first minute and 89 cents for each additional minute. This call is from
Wade.
Hang up to decline the call or to accept the call, dial 5 now. This call may be monitored or recorded.
Hello?
Hello?
Hey, Mom.
Hey, babe.
What are you doing?
What is going on?
Should have left.
You shouldn't have. I know. So, were you involved in this hideous thing?
The credit card thing, yeah, but everything else. Who did you talk to?
I haven't talked to anybody.
How'd you know I was here?
It's all over the news. Every time I turn on the news, there's your face. You, Mike, and Bruce, and Tiffany.
Are you serious? Bruce got in trouble?
Bruce is under arrest for murder.
Oh my God, man. See?
He's in the Duval County Jail. I was supposed to go down there tomorrow morning and talk to him.
God. This is bullshit, man.
Well, when they picked you guys up Thursday night, They came after Bruce. They said you guys gave him up.
I haven't even told him anything. I mean, I did the credit card thing, but everything else, I don't even know what happened. Like, they're trying to accuse me of that.
Well, somebody gave up Bruce, and they came down, and he's locked up, arrested for murder.
It's ridiculous.
Huh?
It's ridiculous, man. I'm gonna kill Mike when we get out of here. I ain't gonna kill him.
Yeah, he may not get out of there.
Well, I'll beat his ass whenever I get to Duval with him.
Well, you know he's setting you guys up.
I know he is.
And that's exactly what I told the detective. I said, if anybody's to blame for this, you look at Mike. Because there's no way these two 18-year-old kids could have done this.
No, whole life thrown away.
Yeah. Yep. Pretty much. And then the good thing with you there, then we're going to bring you back to Jacksonville and try you for murder.
Yep.
Unless they find out different. So as soon as you get your public defender, you need to dump this on Mike so bad.
I am. That's the only thing I can do.
That's the only thing you can do.
That's the truth. I gotta go with the truth now.
Yeah.
I mean, at first my instinct was just not say shit, but if he's gonna put that on two 18-year-olds,
Yep.
hell no. He's taking this.
Yep, and that's what he did. When I heard they said that on TV, that they talked to you three in South Carolina, and you three led them to Bruce, I said, I can't believe that they're throwing that boy under the bus.
Well, I'm on. See, oh, God, I told him, I said, if anything happens, you need Bruce's name out of this.
Well, Bruce said he went in there and took him at gunpoint and put him in the trunk of the car.
He didn't even do that. Let's see, Mike got everybody brainwashed. That's what it is. Mike got everybody brainwashed.
I know. That's what I told the detective.
He was talking about if anything, he talking about I wouldn't even be doing this. I wouldn't even be giving y'all money if I thought I was going to get caught. I said, what? Man.
Yep.
Look, I don't want to waste all your money on this. So, can you send me like a check for like $50 a month?
So what?
Because I don't have anything to eat. I ain't got no socks. It's freezing cold in here. I ain't got no shirt. And shirt's like $7 and socks is like $4.
Well, can I bring you clothes?
Yeah, no, you can't bring me none.
Yeah, I can bring you clothes.
Well, get a long john shirt and long john pants and get some long two socks. You gonna come all the way down here?
Well, you said it's only a 4-hour drive.
Yeah. You can come if you want.
Well, I'm not sending you any money. You don't even get money out of me. It's over.
What?
What?
Mama, I got plenty of money in my account.
And do you think they're not going to find that?
That ain't illegal money.
What's that money from?
That's from Mike's settlement check.
Mike's settlement check.
Yes.
Do you really believe there's a settlement check?
I know there's a settlement check.
Has his father and mother come to see him yet?
His mom is supposed to be bailing him out. Supposed to be bailing me out too. And then as soon as we get bailed, we got a hold on us and we're going straight to Jacksonville.
When's she going to bail you out?
I don't know. But, hey, can you look up a number for me?
Whose number?
Paul Harrell.
Who's that?
It's, you remember Miss Sanders, Vanessa's mom?
Yeah?
It's her husband. That's their house. I'm going to call Miss Sanders and tell her to send me some money.
No, I'm not telling other people to send
I'm
you
going
some
to tell
money.
her. I just want you to find the number.
No.
Yeah, Mama, I ain't got no...
He's got cancer. You leave her alone.
Well, I need money. They feed you bullshit food in there. I ain't got nothing to eat. You got to order canteen.
that's breaking my heart. This call may be monitored or recorded.
Hello?
Yeah, I'm still here. I can't believe you're in all this trouble and you're asking me for money. I can't believe that, Alan.
I didn't do nothing but take money. That's all I did. I went with him to South Carolina and I was getting money from him. All he was doing was hitting ATMs. I ain't doing nothing.
They said on the news that all four of you spent the night over at these people's house.
Bullshit. That's bullshit. See, man, you can't believe anything you hear right now because nobody knows anything. Everybody's giving them different stories, and I ain't even told them anything yet.
Well, don't tell anybody anything until you get a lawyer.
I didn't. I ain't stupid. You gotta get an attorney for everybody, and then all y'all gotta come up with the same thing. And or else everybody gonna look like liars, because everybody's gonna lie to get themselves out of trouble.
You just don't say anything until you get your attorney.
But Mama, I need money for real. I tried to help Nikki out. I tried to help you out. You ain't want to help me out.
You tried to help me out. You've been stealing money from me for a year. And now you've gotten into this trouble. You know, I feel bad, but at some point, Alan, you have to take responsibility for yourself.
I do. You got me yelling.
I'm sorry. I'm sorry, sweetheart. Did you get my letter?
No.
I sent you the phone number, but then I talked to the detective today, and he said he'd call up there and give you the phone number.
Yeah, he did.
Yeah, that's good. Yeah, after I called and threatened the police department, somebody finally called me back. I could have been arrested for what I said on his answering machine. I guess, I don't know. It's a little frustrating when you see your kid's name on TV. It's been involved in a murder.
You told me about it. They're trying to frame me for a murder I ain't even do. And you won't even send me no money to get me get by. It's bullshit.
I'll get some stuff together and I'll come up there.
Yeah.
I don't know. I've got to get back to work. I haven't been to work all week. Maybe I'll come up there Saturday. I told Robert I'd go see him Saturday.
Where's he at?
He's in Daytona.
Jail?
Yeah. He's trying to get you a lawyer.
Huh?
He's trying to get you a lawyer. But if they find you a public defender, go with them.
What?
If they assign you a public defender, just go ahead and use him. And because I don't know if Alan's going to be able to help you, if this lawyer guy's going to be able to help.
All right.
He said he'd look into the case, and I gave him all the location and the phone numbers and the detective's name.
So this is bullshit.
So you know eventually all the truth is going to come out.
I can't believe that Tom Bruce.
Huh? Yes. He didn't even confess to all this stuff.
What?
He confessed to it. That's what the TV said.
See, Mike told him, he said, if anything happens, if you take a blame, I got your bail and all that. Does he know that Mike's locked up?
I guess he does. I don't know.
Obviously he don't, because if he did, he wouldn't have said that.
If he's watching TV, it's in the news. You know, in the newspaper in Daytona, honey.
Daytona?
Daytona.
That's everywhere then.
Huh?
God, man. He got Bruce taking the blame, and Mike's got to take the blame for it now, too. So now he ain't even going to be able to bail Bruce out. Oh my God, man.
I don't think there's anybody else that for Bruce. I haven't heard of any yet. I'm going to go down there tomorrow morning and talk to him. And see what he's saying.
So you gonna try to come there Saturday?
Yeah, I'll see what's going on and see if I can get up there. See if they're going to pay me for this week.
Will you please give me a number, look up a number for me?
No, I'm not going to look up that person's number because she's going through cancer treatment. You don't be bothering those kind of people. She can't be bothered with you. She's holding on to life by a thread. She can't be bothered with you. She's going through chemo and radiation at the same time, Alan.
You had to do the same thing twice.
I went through one at a time.
But in 2 cycles.
It was hard enough doing the chemo and then the radiation. I don't think I could have lived through the chemo and the radiation at the same time. That's hard. That's real hard.
She ain't as old as you.
Man, you leave them alone. She's got her problems. You leave her alone. She doesn't even have a
I don't want to
job.
talk to her. Paul has got plenty of money. He gets paid at the end.
Well,
Mama, I'm starving here. I'm freezing.
you're just going to have to tough it out until I can get up there.
Okay.
You didn't listen to me before.
So what?
If you've never listened to me before, you need to start listening to me once in a while. I tried, Alan. I tried to help you. I don't know what I can do now.
You can be there. That's what you can do. You can be there. You talking to me like I did this shit.
I'm talking to you like you got yourself involved in this stuff.
And I did.
You didn't need to. If you'd have stayed away from that kind of crap, if you'd have just got a job like I asked you to do, and kept your nose clean. But that's not your style. That's not your style.
I understand that, Iris. Good.
I know, you're in a bad place.
I accept my consequences. I understand. But I can't change what happened.
No, you can't.
Now I got to deal with it, and I need you to be there with me.
You have 60 seconds remaining.
Hello?
Still here, you got 60 seconds remaining. I'll try to get up there this weekend.
Will you please write me a check for like $20? I can get the address right now.
What?
Will you please write me a check for like $20?
I can send you a check. They won't give it to you.
Yes, they will. They'll put it in my account. They've got campaigns you can order like food and chips and whatever. You can get socks and shirts and all that. Yeah?
Yeah, I hear you.
Write this address down.
What address?
The address I'm about to give you.
I know the address to the detention center.
What is it?
I've got it written down. I sent you a letter.
Why didn't they give it to me?
Is it L-E-E-D-E-S Avenue?
Leeds. L-E-E-D.
Well, I wrote it down wrong then. I hope you get the letter.
That's all I have.
Members of the panel, any have any questions about particular reason, sorry, or
state said 175, I was publishing at 176.
All right, our jury has returned. Be seated, ladies and gentlemen. Members of the jury, I want to apologize for making you all feel like yo-yos this afternoon, but there's just some things that I need to do out here on the record with counsel that's not part of your responsibility here. So in your absence, both the state and the defense have now rested in their entirety. So we have received all of the evidence. There will be no further evidence to come for your consideration. We are therefore at the point at which I will need to discuss with counsel some customary matters that are addressed at this point in the proceedings, as well as I intend to go over with them the instructions on the law, which I will give you tomorrow, some of which you will have heard, probably, I hopefully will remember from when we first spoke about this, I guess it was last Thursday. So that will take us a while, and clearly that's, there's no way we can begin the arguments now. What I'm going to ask that you do is return tomorrow morning at 9 o'clock. We will start immediately with the closing arguments, and then the instruction from myself, and then the matter will be tendered to you for your deliberations, however long you need to consider this. It is now critically important, now that you have heard all of the evidence, that you not talk to anybody or have any outside source about any of this, because I have yet to advise you on what the law is and how you're to apply the law to the evidence, which you may or may not find from the testimony which you have heard for the past 3 or 4 days. So no television viewing, certainly no news, no newspaper, no Google, no Facebook, no Instagram, whatever the magic things are these days. I have a wife and daughter to take care of that for me. So please, no external information. Please have a pleasant evening. We'll see you back here at 9 o'clock tomorrow. The jury has left the courtroom. Ms. Miller.
Here, moving the court to directed verdict on 2 aggravators, I'm going to address the avoid arrest aggravator. We're essentially moving for a judgment of acquittal and asking the court not to instruct the jury on avoid arrest as one of the aggravating factors. And Mr. Johnson will address especially heinous infringement. I'd like to direct Your Honor, and I apologize.
Wait, stop. Agree, disagree, Ms. Rahes? What?
Disagree. They should not be dismissed on
What evidence is there of avoiding arrest at this point?
Nixon said that.
Oh, okay. I forgot.
And I apologize, I didn't get an opportunity to bring a case for Your Honor. I certainly can, for Your Honor, staff attorney at the Mr. Rocky, but it's Davis v. State, is 148 Southern 3rd, 1261. It's a Florida Supreme Court case from 2014. Interestingly, I reviewed prior Florida Supreme Court opinion regarding Mr. Wade to see if there was any direction. And obviously, progress was there, and we have better familiarity than I would. But I couldn't see any evidence from the record that defense counsel at the time contemporaneously challenged the state's presentation of the avoid arrest. So I didn't see that that was reviewed because there was no objection to it contemporaneously as far as I can tell. Because in this case, I'm referring to a head note.
And understand, I have no recollection one way or the other.
Well, you were there, I wasn't, but I couldn't find any reference in the record to defense counsel
Understand.
objected to the presentation of the evidence supporting avoid arrest. But so the head note I'm referring to the court in Davis v. State, and then I'll refer to the opinion itself, it's head note 16, and this kind of succinctly puts it, evidence did not support trial court's finding of avoid arrest aggravator as would support the imposition of death penalty, sexual battery, and murder prosecution. Although the victim knew and could identify defendant, the defendant drove around with the victim's body in his car. There was no direct evidence the defendant's motivation
Mizrahi?
Not the entire argument falls flat when there's one direct evidence, two, there's tremendous circumstantial evidence. The only way to make a bank has to be extraordinary lengths to pin out the summers, take them, where they would never be discovered. Very remote evidence, dispose of them only after hitting the ATM, then proceed to go to ATM, all of which we call into the sheriff's office, and the boys doing it as part of this conspiracy to assume the summons identity. There's only one reason which has to lie, occurred, to want the money, killing. Robbers of this for money, motive for killing. Relevant pecuniary gain, continued pecuniary, not.
Brief response, Ms. Miller?
I would agree with all the factual assertions that Mr. Mizrahi made, but to say that it undoubtedly establishes that the motive was for rob. Everything they did was to rob the summers. And then referring back to the Davis opinion, it was instead included circumstantial evidence in this case is insufficient to prove witness elimination, which is used interchangeably with accidentally arrest aggravator, was the dominant motivation behind the murder, and the trial court therefore erred in finding this aggravator. So what I obviously emphasized, tone was dominant motivation. The dominant motivation was undoubtedly in Mr. Wade's case, his co-defendants, to rob the Summers. So I just, everything Mr. Mizrahi said, I agree with all of it, except for the purpose in doing all of that was to get their ATM information to rob these folks. So I certainly don't think there's circumstantial evidence which the dominant motivation behind the actual murders of the Summers was to avoid arrest.
I'm going to leave that one up to the jury. I will give that aggravator. They have the right to decide, and you have the right to argue that there isn't any evidence of it. But I will instruct them that that's one of the aggravators. Mr. Johnson as to, I'm sorry, heinous atrocious, was that the? I'm sorry?
It's not a motion for directed verdict, it's a motion for a special instruction.
Okay. Tell me again, Blake.
Would you like to address it now?
Yeah,
I will be moving the court for a special jury instruction. I have this tradition writing, I'm trying to get it printed out. But essentially, in the Cole case, one of the reasons that it came back from, well, it wasn't the Supreme Court. The Supreme Court said act cannot be vicariously imposed on the defendant. By all accounts, in the prior trial, Nixon testified that since Cole was at the car, hack could not be applied to her.
Right, I remember that.
We are requesting the jury instruction because the jury is free to believe or disbelieve the various roles within the players in this cast. They have to believe Bruce Nixon's testimony that Wade was one of the people that actually murdered them. Otherwise, they can't vicariously apply that. They have no way of knowing that. Additionally, the testimony is that we heard from Bruce Nixon that was put in from his prior testimony is that they were under the impression that these soldiers were going to be killed in a different manner than the way they were killed. Michael Jackson specifically said that they were going to be killed with a shot. And I would just read from Cole's case. And in Cole, which is 36 Southern 3rd, 5 believing at this time that it would be inappropriate to charge the jury on that, but what I'm suggesting is they need to be advised that if they have a reasonable doubt as to the aggravator, they cannot vicariously apply it. In order to receive a special jury instruction, Stevens v. State 787, Southern 2nd, 747 says, in order to be entitled to a special instruction, the defendant must prove 1, the instruction is supported by the evidence, 2, the standard instruction did not adequately cover the theory of defense, and 3, the special instruction was a correct statement of the law and not misleading or confusing. I think it is far from clear in the standard instructions that cannot be vicariously applied.
The only evidence that the jury, Mr. Mizrahi,
I would say that very different from Cole. Direct evidence, Cole makes it say Cole is not.
Throughout.
In this case, Wade came from the gravesite. He left Jackson Wade at the gravesite. There's a different factual component. Cole, I have no problem with arguing, Cole's argument, but we have to do that. Credibility issues with Bruce Mitchell, whatever it is, standard instruction contemplates what the defendant did. It says that. They can argue that for the counsel. This is what they have to do.
Judge, if I could just briefly, the Cole case, the court, what the court was saying was that it was improperly applied, and that's why it came back. That was the error. This is some
the evidence in Cole was, from the outset, was that she was never at the grave, never, I don't remember whether she participated in digging the hole. I don't remember about that. But in the I think that she did, but in the deaths, she stayed up on the road and never went down to put them in the.
But the difference here is that we're just asking that the jury be advised that there's this idea that hack can't be applied. The only proof of who did what exactly comes from Bruce Mason. He's not the most reliable of witnesses, and we're asking that the jury be instructed. They can make a decision. We're not asking the court to strike it from the jury instructions. We're just asking. And additionally, I will only say as my last point, Bruce Nixon he wasn't there. He testified that he wasn't at the actual funeral hole and doesn't know what happened there. He says he left and that Jackson and Wade stayed there. There's no direct testimony as to what exactly went on at all.
I'm going to leave this up to the jury also. I'm not prepared to try and explain to them what vicarious liability is. I will certainly argue. I'm already going to tell them that they got to find beyond a reasonable doubt, which is unanimous. And I will give you the opportunity to suggest to them why they shouldn't, And it may be a very fair argument on your part. I'm just, But I will give the motion for special instruction, which I have received. Is this your count? Is this the original? Okay. Well, in any event, the motion for the special instruction is denied.
Your Honor, I'm sorry.
I'm sorry?
Is that the motion?
That's the one the motion for special instruction regarding hire? Yeah.
Okay, so
Oh, well, Leslie printed it up for me. Okay, I have it.
Is it filed for the record?
Okay. Yeah, you got it. All right, done. All right, shall we discuss other matters then? Other than the charge conference? Any other procedural matters on it? All right.
Your Honor, I just want to clear up the record. I know we made several motions for the trial just to do something you deny with on my statement.
Yes, that's true, Mr. Richardson.
Thank you, Your Honor.
I have an updated mitigators list based on the presentation of evidence that's included today. May I email that to you all now, or would you like me to print it?
If you will email it to Leslie, she can print it for me right here.
I would like to email this. assume we're gonna incorporate it in the standards on top.
That's my preference. Leslie, need your... And to Leslie.
Amendment. You got a copy? Oh, I'm sorry. I didn't know. Have you had a chance to I'm sorry, you're still working on the list. Ms. Parker, this was Rahi.
I've had, I mean, I'm sure there's some of it similar to the last list. We can go through them one at a time.
Yeah, can we do that? Because I've got a couple of minor concerns.
My suggestion, Your Honor, if it's okay with the defense, Your Honor, is just go through the instructions, so I make corrections as we go. I have found it useful to use the, I don't know what it's called over there, to publish it, so we can see it. You just go through the instructions, and I can make, this will be the main copy, and I'll make corrections.
Okay. And now we're talking about the instructions or the mitigating circumstances list right now?
I think we should go through the instructions, and then when we get to the mitigating list, we'll have.
Okay, well, all right, well, somebody needs to give me a,
It's going to be on your screen.
okay, what screen? I don't have a screen.
You don't have a screen? No, no.
No, I don't.
Paper to be able to write.
Well, actually, that's kind of why I was looking, you know. No, I do not, I've been using the one down there with the clerk. Is there, can you, huh? That one, what is it? Okay. All right, this is the preliminaries, that's not what we want. Is that? Okay. I'll just work through this. Oh, okay. Okay, that's fine, okay. All right, I'm with you. Actually, I do have what, yeah, I don't think I'm tied into the. Yeah, there. Yeah, see, that's not this, that's this.
You can come help me if I have an issue.
Okay. I do have it now. Okay. Go ahead.
Okay, so we're on page 1, the final instructions. 2 possible punishments, life with imprisonment without the possibility of parole or death. I'll just scroll through and wait for defense. I have highlighted some things that probably need discussion. So the aggravating factors by the state are, just too far, was previously convicted of another capital felony. The crime of first-degree murder is a capital felony. And then I highlighted because I think this instruction.
I'm sorry.
So Alan Wade has been, I don't know what to tell you about that.
Can you scroll back up? I'm sorry. Okay. You can go down.
So he's previously convicted of another capital felony, and obviously he's been convicted of 2. So I just highlighted that additional instruction for the court to give. So I'll just keep scrolling.
Well, it says Alan Wade has been found guilty in this trial of 2 counts of first-degree murder for those convictions and those convictions. So I'm objecting in this trial and those convictions written twice.
Okay.
I agree with the end, those convictions written twice. I could just get rid of in this trial.
Please do.
The defense proposal said kidnapping and robbery. State has taken out robbery because I don't want any merging instructions, and I'll just be arguing the kidnapping is the enumerated felony, since the robbery would merge with pecuniary gain.
I don't have an objection to that. I do have an objection to what Mr. Misrati has highlighted. This aggravating factor has been proven beyond a reasonable doubt based on Alan Obtain and guilty in this trial, 2 counts of kidnapping. I think whether or not something has been proven beyond a reasonable doubt is for the jury to decide.
I agree. I've deleted it. I've now included, I highlighted these, this is very rough. I've included to say Alan Wade has been found guilty of 2 counts of kidnapping.
Well, I'm objecting to that as well.
Okay.
State hasn't introduced any evidence to that.
Well, I told them already that they were here because they'd been convicted of
2 counts of murder, I would
counts
agree.
of,
State has to prove that he's been convicted of 2 counts of kidnapping.
Well, it's a matter of the trial record, Your Honor. It's the record of this style case is he's been convicted of kidnapping.
I've done a number of first cases, and the state has introduced evidence to support the foundations for the conviction. They don't get judicial instruction. They have to prove that the existence of an aggravating factor.
They didn't have to prove the murder.
Correct, because we're here for sentencing on the murders.
well,
We had this conversation in jury selection to a certain extent, in that, again, I've done quite a few cases that were remanded for resentencing pursuant to hers. In every case, the state has introduced certified copies of judgment sentence, because they have to establish evidence to support a jury finding beyond a reasonable doubt the existence of factors. And they're essentially asking the court for judicial notice of an aggravating factor that they have to prove unanimously and beyond a reasonable doubt.
Mr. Mizrahi, there is some merit to that.
Well, if that's the case, then the state's going to be moving to reopen its case for the pointless purpose of establishing that the defendant was convicted of kidnapping in this case, which all the parties have agreed and stipulated to and talked about in jury selection and talked about in opening. And it is a matter of law, of record, in the above-styled case. This is not I would agree with defense counsel to the extent that if this were a prior felony of a different case, this is this case number. We're giving the jury the instructions on this case number and this indictment, and he was, as a matter of fact and law, found guilty of kidnapping.
Yeah, all right, I understand. I'll give it.
But I would also say that I attempted to ask about it in jury selection, and the state objected, and the court sustained that. So frankly, at that point, we had a conversation about whether the state was abandoning seeking that aggravator. And so we're now instructing them on things that have not been proven in this case.
Okay. Yes, we are.
I would just say for the record, my objection was discussing the sentence.
I don't recall. So I will give that as proposed.
And number 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Number 4, the first-degree murder was committed for financial gain.
Wait, before you move on, obviously, we're objecting to number 3 being given as a matter of.
I assumed that, given the previous,
Yes, sir.
Number 4, the first-degree murder was committed for financial gain.
although, wait.
I'm sorry.
The objection was not to the aggravator. The objection was, the request was to give a specific instruction.
2 different things. That was, number 3 is the avoiding arrest. I am objecting, that's one we moved the court for a directed verdict. We're asking the court to not instruct the jury on the avoiding arrest act.
I'm sorry, and the other one was HAC. I'm sorry.
Yes, sir.
You're right. Okay. The objection's overruled.
Number 4, the first-degree murder was committed for financial gain.
Yes.
Number 5, the first-degree murder was especially heinous, atrocious, and cruel.
Okay.
We're again asking for the special instruction.
The only thing I would point out is I do say unnecessarily torturous to Carol and/or James Sumner. I think that's appropriate, so you don't have to read it twice.
I disagree.
Number 6, the first-degree murder was committed in a...
There's going to be 2 verdict forms, and so Mr. Mizrahi combined, instead of writing this twice as it applies to Carol.
Got it, okay. I misunderstood what he was saying. Okay, I'm with you.
Number 6, the first-degree murder was committed in a cold, calculated, and premeditated manner. Standard instruction. Number 7. You ready? Number 7, that Carol and/or James Sumner were particularly vulnerable due to advanced age or disability. Those are the 7 aggravators. I have the victim impact highlighted because I would appreciate an emailed copy so I can cut and paste the proposed instruction.
There was a second paragraph to
Right.
the victim impact that I don't have up here.
So
Okay.
they're going to email it. I'm going to cut and paste what they email me into that spot. Then we have, and we'll go back once we get it. And then we have aggravating factor proven beyond a reasonable doubt, standard instruction. Ms. Miller, just let me know if I can keep going.
Yep, I'm good.
Yep. So we're moving to the mitigating circumstances.
Wait. Okay, it's we are, all right, you're okay with that paragraph, and then we go to among the mitigating circumstances. I'm fairly certain, I haven't looked recently, but this is all standard, I think, so, you know.
We agree with everything so far, other than the reason injected.
All right, and so among the mitigating circumstances you may consider are, and shall we then switch to the proposal that Ms. Miller has provided us this afternoon, or
I have cut and pasted the most recent proposal in the instructions on your screen.
then I will keep my mouth shut and,
So the state has no objection to 1, 2, 3, I have an objection to number 4. I think it should just say the age of Alan Wade at the time of the crime.
I agree.
Well, I did take out the part that the court had indicated was objectionable yesterday. These are all factual statements. These 18 years old.
That's argumentative.
These 18?
18 and 47 days. I will gladly ask them to consider, and you will capably argue, I'm sure, or Mr. Johnson will capably argue the matter of his age at the time of the crime.
Okay, I disagree, but I understand which one.
Okay,
And just numerically, we're going to ask that they just be like, it's 1 through 5 and it starts over at 1. We're going to ask that they just be continuously numbered.
Come on.
Okay,
I'm just not technologically capable of switching.
okay, that's fine. Okay, before we worry about the numbering, let's see how many I cut out.
Okay, yes, sir.
You should go into it with that in mind.
All right, so So I guess with that request, we would delete number 5.
That's fine.
Yeah, well, that's
Yeah.
That's a general instruction, that's not a mitigator. I mean, I will have told them already about that beforehand.
Yes, sir. So I'm deleting that. And I'm just going to say the numbers that are here, obviously, we're going to change them later. But Alan Wade was neglected and abandoned by his parents, I have no objection to. I have no objection to number 2. I do have an objection to number 3. I think there are facts, I think this was alluded to, but I'm not sure that these facts were specifically enunciated. I think that, frankly, the better
I
way.
don't remember any reference to scary movies, but, you know, it may have. I'm getting nods. I mean, I do recall the touching of the penis. I don't know that scary movies makes a difference in the grand scheme of things,
No,
but.
because there was specific testimony that she would put Alan in a position of vulnerability where he, in the scary movies, that's why I wanted to make sure all of this testimony was
All right,
introduced.
okay.
And the point was that he was put into a position of vulnerability to need her comfort, and then she took the decision sexually.
And I would say there's something every time. I mean, I can't, you know, it's hard to,
You can take out every time, I would agree. When she babysat,
the state's objection is that it should say Alan Wade's babysitter sexually abused Alan. And that's what it should say. That's the mitigator. And the facts and circumstances surrounding it are up to the jury. And I really, frankly, don't have a huge of points that Alan Wade's babysitter sexually abused Alan between the ages of 6 and 7. I don't have an objection to that.
I'm not asking for sexual abuse, I'm asking for what you propose, because that's what is established by the
Okay.
evidence.
I'm going to strike the matter of under the covers while watching scary movies because it sounded to me like there were more instances than just the one. Alan Wade's babysitter touched his penis. I can add in several times if you want, on more than one occasion or something like that between the ages of, well, actually that's covered because it was between the ages of 6 and 7, so.
Obviously, we're asking for this, understanding the court's ruling. Alan's babysitter touched Alan's penis when she babysat Alan between the ages of 6 and 7 years old.
Yes. Got it, Mr. Mizrahi.
Several times?
No, I don't know that it says between 6 and 7, so it had to be more than one.
So I've put Alan Wade's babysitter touched Alan's penis when she babysat,
Between the ages of 6 and 7.
when Alan was between the ages of 6 and 7.
Yeah.
I can do, you want
I
me
think
to,
that could still imply it was only once, like it happened one time between the ages of 6 and 7. The testimony was that it happened more than once.
And were repeatedly after.
I'll concede several times. Alan Wade's babysitter touched Alan's penis several times when she babysat him, with him between the ages of 6 and 7.
How about when she babysat Alan between the ages of 6 and 7? Take out the second one and take out once. When she babysat Alan between the ages of 6 and 7.
okay, we're on to number 4. Yeah, that's what Mr. Cooper said.
Hey, write down your numbers. Mr. Mizrahi,
Hold on a second. No, I can't do 2 things at once.
great. Don't change the numbers, because we have paper. You can't change it yet. Right. There's some people that are following along on paper. On number 3, can you please change it to Alan Wade's babysitter touched Alan's penis when she babysat Alan between the ages of 6
Where do you want me to put it several times?
On several occasions at the very end. Do you need it there?
I'm not sure that that's grammatically correct, Ms. Miller, but we won't go there.
You know, so I technically would say.
I don't remember whether it's a modifier or whatever, but it doesn't matter. God, and how many of these have we got to go through?
Yeah, I mean, I thought I had it. How about that? Number 4, Alan Wade's brother, Andrew's friend, Sean Adair, performed on, I have the same type objection. I don't think any of this came in, frankly. I think there was testimony about Andrew's friend abusing Alan, but I don't think these details came in.
Okay. Be very specific attention, and all the details did come in from Dr. Castillo and Dr. James. I believe both doctors specifically elicited what occurred.
Yeah, I agree, Ms. Rahe.
I know. I mean, we heard the name Sean Adair. I think we heard.
In her PowerPoint.
Well, I did hear Sean.
Right, and I changed the spelling of Sean, because I had S-E-A-N when I sent you previously, based on her PowerPoint. That's why I knew it was in there.
No, I'm just. We were broadcasting in public that Sean Adair is a rapist. Anyway, I guess that's his problem. Okay.
Number 5, Ms. Rahe? I'm sorry, were you ready on the?
Yes, there is, in my opinion, no evidence about, there's evidence that he was banging his head against walls, but the reasons behind that, I don't think were elicited. I do think that there was a First Assembly, there is evidence of a First Assembly exorcism. I think she said similar to CPR. I don't think she said slamming his head on the floor. I think she said CPR. So, I mean, these are statements, you know, I do acknowledge that there were things on that screen that she had testified to. But, I mean, again, I think these are way too fact specific. Anyway.
And I would say the same thing that the court said about the aggravators. The state is required for the aggravators to have to rule it out and you send it back to the jury. Here is required to establish the mitigators. My position is there is no burden. The instruction says about the greater weight of the evidence. If Mr. Mizrahi wants to argue that this mitigator hasn't been proven because there's no evidence of why he banged his head at the wall, that's the state's purview. These are the requested mitigators that we're asking the jury to instruct.
Well, I will give it this way. Alan Wade began banging his head into walls at the age of 5 years old. I don't remember anything about ridding himself of bad thoughts and dreams, but I do think that there was evidence of an attempted exorcism, or words to that effect. I don't remember similar to CPR. I think I deduced that, but I don't.
That was a direct quote.
Okay, all right.
I do remember the CPR quote, Your Honor. What I don't remember is slamming the head on the floor.
I added all as she was saying.
I'm sorry?
I added all of that language as Dr. Castillo was talking
Okay,
about.
all right. So I'll delete the matter of ridding himself of bad thoughts and dreams.
The ages of 6 and 7.
Oh, yeah.
I'm sorry, say again?
The ages of 6 and 7, not the ages of 4 or 6.
6 and 7.
Corrected.
I'm sorry.
I think we're done with 5. We're on to 6.
Yes.
I think there was, I don't know if there was, I have no idea if there was testimony as to this. I remember the pastor's son was mentioned, but in terms of who forced who and throwing against the wall and the ages and that he was an adult man.
And Dr. Castillo talked about when Alan Wade was alone at the church, people would pin him up against the wall, and that Dr. Castillo and Dr. James talked about how this was the most violent of the incident.
Number 7, I'll give 6 as is proposed. I don't see how the state could have any objection to 7 and 8.
I have no objection to 7 except the word frequently. I think he was jumped, I think there's testimony that he was jumped and beaten. I think frequently is, but I'll leave it, it's fine.
I think she did say it happened on more than one occasion, so I'll live with that.
I have no objection to 7, I have no objection to 8.
None.
I don't remember any testimony about holes in the floor and a broken septic tank. And to the point, Alan played in dark waters, I don't know what that means.
I agree. I mean, I would give Alan grew up in poverty. I don't remember anything about him boiling water to make himself feel good. That doesn't make.
There was specific testimony about that when he was living in the woods, that he would boil water because he didn't have any food. I guess we take out an attempt to feel full at times.
Well, if I do that, then there's no sense in the water.
Right.
He's boiling water to make poke salad or something like
Right,
that.
that's the point, is there's no other reason why you do that. And that was also specifically in Dr. Castillo's slides.
Okay. I will give the line which says Alan Wade grew up in poverty and nothing more on that. I don't think there was any evidence about him playing in dark waters or.
Specifically said that. That's
Okay. Nevertheless, Alan Wade grew up in poverty. Number 10, I'm sorry, you're editing.
Yeah, number 10, I have no objection to. 11, there was testimony of, I have no objection to. Number 12, I have no objection to. I mean, then again, it's, so it's these conclusionary words that Alan's Wade mother was unable to parent. But I mean, I guess if that's what they want to prove, I have no objection to 13.
I'm okay with 10, 11, 12, and 13. I think clearly she suggested that. What about 14, Mr. Mizrahi?
Well, I think I have no objection, except the last line. I'm not sure where that came from. So this is how Alan learned his mother had cancer? I don't remember that.
I don't remember there being any evidence about that. So we'll delete the phrase, this is how Alan learned that his mother had cancer, because I don't remember anything at all about that. I thought that, well, I don't remember.
Again, it's hard to remember what's in these slides. I asked the number 15. I would have no objection. I don't remember abandoned jail.
Yeah, I was going to ask you about that. Was that?
I can add that specifically when Dr. Castillo said that, she both said it and it was in her slides.
Okay.
Okay.
All right, I'll give it that way.
Number 16 is fine. '17 is fine.
Yeah, there was one, let me back up just a minute.
Yes, sir.
I had made a note earlier. Back in number 8, Alan Wade's mother, Frida Gainey, abruptly murdered herself, Alan and Alan's brother. I don't know that I'm prepared to read that, because I am planning on reading that. I mean, I think it's obvious that she moved, but abruptly, to me, just seems argumentative. You know, I'm not sure that I want to take that position if I'm reading this, when I will be more than happy to read Alex Wade's mother, which is consistently with her testimony, moved to McClenny when Alan was 8 years old. I don't.
Alan Wade Sr. testified that he came home and there was no.
They were gone, yeah.
And Frida also said that she packed the kids up and left. So I could have been more descriptive.
All right, stop, okay, I'll give it. 16,
16, the state's okay with. 17, the state's okay with. Dang it. 18's, the state's okay with. 19, I'm okay with. 20, I have no objection to saying Alan Wade threatened suicide. The wanted to die part is the objection the state has.
A tremendous amount of testimony about Alan Wade.
yeah, I'm gonna, I'll give that.
I have no objection to 21.
I have a query about 22.
Yeah, I think that
He repeated sixth grade twice, and he repeated seventh grade once. How do you repeat seventh grade once?
So he did sixth grade 3 times, which he moved to, and seventh grade 2 times. He was 16 in 8th grade. Right, one of the jurors even asked that question. It seemed like he was in the 3rd time of 6th grade, and then,
Well, and that's why I asked, because it didn't, does that count right?
yep, so he did
If he repeated sixth grade twice, that means he did it 3 times.
And then Frida took
And
it
he
out.
did, and then he did seventh, he repeated seventh grade once. That's 5 years there. Okay.
state's fine with that.
Okay, go ahead. I will say, I don't remember any specifics about failure to complete assignments, but I think that kind of fails. Mr. Mizrahi, next one.
State's 23 is fine. Not so sure chokeout games should be capitalized.
It seemed like a proper noun.
Not sure that's a proper noun.
I
But
don't
anyway,
have an objection to it being lowercase.
Uh,
I want to ask the court, because the agent was kind of pull up from you. The court is instructing the jury that Alan Wade grew up in poverty.
Right.
And I think there are different standards of poverty. And so I.
Melissa, a rule.
I know, but Your Honor, I would like to bring your attention to the PowerPoint presentation from Dr. Castillo that specifically says cold on the floor, broken septic tank. In that testimony, was specifically listed, and so I can appreciate if the court doesn't want to get the dark waters part, although that was specifically testified to, but I think that poverty can mean a lot of things to a lot of people, and so you're talking about poverty to the extent that you live in a trailer with holes in the floor, a broken septic tank. And so I'm asking that the court reconsider removing that language, given I think there was testimony to support it being instructed.
Thank you. No. Mr. Mizrahi?
forget where we are, but, the chokeout game, number 23.
Take out captain, choke out game.
No, I have no objection to that. I just made it lowercase. I don't think it's a proper noun.
It's fine.
More of a joke. 24, dropped out before completing 9th grade. That's true. 25,
I have some hesitation about that. 25. I thought the evidence was pretty clear that the drug descent happened long before the breast cancer.
yeah, it began before the breast cancer, obviously.
So, I mean,
It increased during the breast cancer.
Right, and that's what his mother's testimony, Frida started before I got cancer and then took a sharp turn. That's exactly what the words were that she used to describe his drug use and truancy when she got cancer.
Okay, well, I'm going to strike the word dissent. Alan Wade's drug use and, well,
Instead of
the problem is that
coincided,
there's a lot of evidence already that the drug abuse started before, you know, and I'm not comfortable about commenting on the quality of what Ms. Gainey said. I mean, that's my concern.
Right, well, except for the testimony is that, to be very specific, he tried some sips of beer when he was 4 or 5, and he started really drinking alcohol at age 11. He started using marijuana at 12, and so cocaine, I think we would all agree, is certainly a step up, and that is 13 is when Ms. Gainey was diagnosed with cancer. So when Alan started using cocaine and pills and drinking daily, I think that directly coincides with his mother's declining health, which is consistent with her testimony that he wasn't doing great, but then it took a sharp turn, for her exact words, when she was diagnosed with cancer.
Had the word serious with them. Serious offenders.
All right, I feel better about that. I don't know why. Mr. Wade's dissent in the serious drug use, because I think that is more consistent with the evidence, directly coincided with her declining health. Okay, I'm with it.
so I've included the word serious.
Okay,
Number 26, no objection. Number 27, I have an objection to the semicolon part after 2003.
Oh, you object just to my grammar, or you object to the words?
No, I'm saying that it should not say Alan's mother, Frida, was unwilling to contribute financially to Teresa, so Alan was forced to return. It's conclusionary. In fact, Ms. Rodian said, I asked for money and she took her kid back. And then Ms. Gainey said, what she testified to quite eloquently was that she didn't want somebody else, she didn't want to pay somebody else to take care of her kid. It was her responsibility. So anyway, that's my objection. I don't want to debate it.
I'm going to leave it as is. I think there is some conflict within the testimony, but y'all can talk about that. Number 28.
There was the change the locks. I don't know what evidence there was of that.
Said in great detail a number of times. Because Robbie across was like, you're a tough love gal, and she said, yeah, but if you throw my kids out and change the law. She repeatedly said that. In response to the statement.
I'm okay with 28 the way it is.
I have no objection to 29, and no objection to 30, and no objection to 31, no objection to 32, no objection to 33, no objection 34. I have an objection to 35. I have no objection to the first line of 35. Alan Wade experienced toxic stress from exposure to ACE, but explaining what toxic stress from ACE can damage is not.
Well, my note was that sentence or two is argumentative, and I wouldn't be inclined to give it. Clearly, the evidence is that he experienced toxic stress from adverse childhood experience, but I don't think it's appropriate for the mitigator to be argumentative in support of it. That doesn't mean that the council can't talk about it.
And the aggravators, for instance, one is victims who particularly vulnerable to that age of disability. There's nothing in
Okay.
recommended,
The mitigating circumstance is that he was exposed to toxic stress. Why do I have to explain what toxic stress is?
you know, what was supported by the evidence. I'm not asking.
No. I'm not, my thing is, why is the definition of toxic stress something that I have to tell the jury is a mitigator? I'm not saying you can't talk about it. I'm just saying, why is the we haven't defined anything else. Did we define poverty? No. Did we define care? No. Or lack of.
We define everything in the aggravator, especially in.
I'm not talking about the aggravators, Ms. Miller. We're talking about the mitigators right now. Okay. I'm not going to give the sentence about defining toxic stress. I will stop at the adverse childhood experience, and I will not give the remaining sentence. Number 36, Ms. Rahi.
I mean, again, we have things like life theme. I think you could put Alan Wade described his childhood. His childhood was described as looking for guidance or acceptance. I don't know about life theme.
I will give it as proposed.
Number 37, I have no objection to Alan Wade found guidance and mentorship. He was searching for Michael Jackson. When they put in parentheses, a career criminal or master manipulator, I object to the parentheses.
I am not going to give that phrase. I don't care who testified to it. I am not going to give it.
I object, but I understand.
Nice try, though, Ms. Miller.
Number 38, Alan Wade was provide drugs, money, and...
Sorry.
I'm sorry.
I'm sorry. Where?
Number 38, Alan provided drugs, money, and a place to live. 38. I guess there's evidence of that. That's fine.
Okay.
38. 39 is okay. Yeah, Your Honor, I agree that there was testimony that brains are not fully formed at 18.
Okay, wait. You okay with 39?
Yes, sir.
Okay, sorry.
Number 40,
That's pretty much consistent with Dr. Castillo, Ms. Rahi.
okay, that's fine.
Maybe not, okay. I'm inclined to give it.
Yes, sir.
As well as 41.
Yes, Your Honor.
I think there is evidence of that.
Yeah, 42 is, I object to giving it in its entirety.
I specifically made it not argumentative. That was what Dr. James' testimony was verbatim this morning. And the court's a lot of questions by the jurors, and a lot of them want to understand.
Okay, explain to me, and I'm just trying to work with you. Alan Wade's life at the murders was the perfect storm?
That was the exact word, Chief. That's why I put it in the book.
I think it should say time of.
Okay, that's just not the murders.
What?
I was working on these as testimony.
I understand, Melissa. I'm trying to understand what, I thought she was saying with the murders was the perfect storm, but I may have,
So she said in response to Mr. Johnson and in response to one of the jurors' questions about, certainly you're not saying everybody who's exposed to adverse childhood experiences commits murder. And she said to Mr. Johnson, quote, "It was a perfect storm of the adverse childhood experiences, plus drugs, plus the fact that Mr. Wade had a juvenile or an adolescent brain, plus Michael Jackson."
I'm not sure that I understand what the aggravator is.
Mitigator.
I don't, I don't feel like I understand what it is, so I don't know what I'm telling the jury. He was in the perfect storm at the time, or?
Your Honor, the problem I have is they're essentially taking every mitigator above and combining it into one. It's almost like the merger concept, is you can't double dip. They're repeating specific mitigators and then putting them all in one mitigator and calling it another mitigator.
No, because this one's, I get Mr. Mizrahi's point, but that specifically we were talking at 42 is about at the time of the merge, right? So it's, he had all of these other things, but we were talking about specifically when Red Tape Carol son of a murder, Dr. James described Alan Wade's life and his behavior as the perfect storm of those four aspects of his life. The adverse childhood experiences with drugs, the adolescent brain, enter Michael Jackson. So the other mitigators talked about different parts of his life. This one is specifically at the time of the crime.
Mr. Wade's behavior at the murders of Reggie and Kara Stummer was indicative of the perfect storm of adverse childhood experiences, including his use of drugs and including use of drugs, adolescent brain, and the influence of Michael Jackson, or something like that.
With utility including, it's adverse childhood experiences. Drug use is not an adverse childhood experience, nor is adolescent brain, nor is Michael Jackson. And so it was just adolescent childhood experiences and drugs and adolescent brain and Michael Jackson.
In addition to,
I like in combination with.
I'd rather it be given the way it's written, Your Honor. I would rather it be given the way it's written.
Well, okay. Alan Wade's behavior at the murders of Reggie and Carol Summer was a perfect storm of adverse.
I objected that his behavior was that those two things equaled each other.
Well, I'm trying to accommodate. You said the.
I withdraw my objection to number 40. 42.
Okay, fine. What about number 43? I think that's probably unobjectionable.
Yeah, no objection.
44.
No objection.
45. Was there evidence that he served as a tutor? From whom?
I've seen that in the materials before. I just don't remember.
I remember Ron McAndrew saying it and.
Okay, all right. I don't remember
That's fine.
that one.
I don't have an objection to it.
Okay, reading, that certainly relates to his allocution. Mentor to Alyssa Jade Craig, I'm okay with that. Number 48.
And those were direct quotes from Dr. James. She spoke with Alan. He talked about.
I know.
I have.
I have no objection to 48.
49.
49, I do have an objection. Well, that's fine, Your Honor. I have no objection to 49.
Thank you. And
Or
apparently
50.
I'm gonna guess that that the state has no objection to number 50.
I do not.
Okay. All right. That said,
If someone wants to come do the numbers, that'd be super.
oh yes, that's right. You need to readjust the outline.
Where's my mouse? Okay, I'm not tech savvy either.
It's not there, it's here.
Oh, that's fine, okay. why are all my numbers not highlighting? Okay, clearly I'm not tech savvy enough for this, because normally it says continue numbering when you right click. Here. Why isn't the mouse moving?
You have to use my thing, the mouse is,
Highlight the whole thing from the top to the bottom and then hit the number. Yeah, highlight the whole
don't delete
thing.
anything.
And then hit the numbering thing. Keep going. Yes, save it first.
Well, that's just-
Yep.
That changes the, is that a problem?
Yeah, we gotta go for the numbering. 2, 3, 4. No, because you need to restart the numbering here to follow the. Yeah, and then click. If you go to set number.
It is usually right here.
I'm sorry.
No, me too.
Try click on the.
It's all right, I'll let you.
Let's see if it works.
Keep using
Oh, I hate that. Define new number format, maybe. Let's see. Number style, number format, alignment. Why is it not letting us? Yeah, set numbering value, it's blanked out. No, go ahead, no, John. What, do you have it? Is it?
Y'all want to help?
I would suggest like backspacing and pressing enter. Yeah.
Did you hear that? From the interns?
Yes, but
Oh, you mean each one?
sometimes you have, well, it's tough. It's not that really. Oh, it's not. I'm not doing the numbers. Yeah, that's Diana. They're not like, wait, that's weird. Well,
Yeah, they were made protected.
but
It's not,
Can you highlight?
the problem is that it wasn't numbered to begin with using this.
We might have to do it manually then.
I mean, it goes back, oops. I have one last idea. We're gonna go back to what we had done before and
Set numbering value on that.
and we're gonna do
Put 2 up to 1 and then hit enter and it'll.
Well, wait, so let her finish, and then we'll go to your idea.
Then
You can't have 5 ideas at once.
Okay, yeah, now take that one up. There we go. There we go.
Randy, we already did that and it didn't work. You missed it.
find out how many it is. Yeah, that's 5, 6, 7, 8, 9.
But this is the preliminary.
Now, do you guys want it to come back underneath the number, the style of it? It's indented?
Because it clearly says.
What's the question?
So before, any kind of hanging was,
It's okay, just-
was over here.
Oh, I don't care about the font. I don't care about
The lamp, the,
I could care less about
okay.
I don't think Judge Weathery cares. I do have judges that do care. That's great, thank you.
Got some misspellings, but,
Well, fix it where you see it.
well, Nikki is not spelled like that.
That's y'all's fault. Just put it in there, put it, go ahead.
I'm not listening to you. Allison, can I fix Nikki's name spelling? It's incorrect.
N-I-C-K-I.
She didn't trust me.
I wasn't going to take advice from Mr. Mizrahi.
I'm not paying your bills.
Yeah, you don't send my checks.
All right, are we,
Oh, well, I'm going to do a,
Are we still numbering? Is that what we're?
Tell her.
All right.
Tell that one. I knew she would like that.
Looks like it's all right.
Okay, Your Honor, we're back on the record, I think. Okay.
So I will read those mitigators that we just discussed.
Yes, Your Honor.
And that's going to be inserted.
So the next paragraph is your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have presented to you during these proceedings. And then we go to the next step is for you to determine whether the aggravating factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist.
Concluding with law neither compels nor requires you to determine that the defendant should be sentenced to death.
Correct.
Any objections to that? Okay. Next paragraph, once each juror and your
Correct.
decision of any with and your decision to impose a death sentence to death must be unanimous.
Correct.
Okay. Obviously, I'll be providing them a form, and we'll talk about that in a minute.
So I have included after the form,
Okay.
this is a standard instruction for 2 counts, so I've included it. You have considered 2 counts of first-degree murder. They've been tried together. Each conviction, the evidence must be considered separately, the separate verdict as to each. So that's the standard. So I guess I need to modify this. You've considered 2. You should probably say you have considered the sentence for 2 counts of murder in the first degree, and although they have been tried together, each sentence.
Mr. Romney, shouldn't it be you are being asked to consider the sentence for 2 counts of murder?
Yeah, and that's why you are, that's good. To consider the sentence for 2 counts of murder.
Mm-hmm.
Yep.
We'll change conviction to count in that last sentence.
Yep. I see it. I see it. Okay. Good. You are being asked to consider the sentence for 2 counts of murder in the first degree, and although they have been tried together, each count and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. Findings regarding aggravators and mitigators as to 1 count must not affect your findings as to the other count.
Okay.
There's an extra D.
Yes, as to the other the count. See that.
Extra D in there.
Very good.
All right.
Then the human life at stake, you should not act hastily, stand under instruction. You decide what evidence is reliable. And then the standard questions. There is nothing for 10. I think everything else is appropriate.
I agree. Certainly no reputation testimony.
Okay, so we'll keep going. The fact that the witness is supported in law enforcement is standard. Expert witnesses.
The standard.
Right. Okay, I have included it. So it,
Brackets, we would like the first one, claims that help the second crime, not the second one. But we are asking to get the last one, so it's the game. Or opposed game. Or, I guess that would be fine. And change the last one.
okay.
Okay.
So the defendant in this case has become a witness. We should delete that. It's entirely proper for a lawyer to talk to a witness. You can rely upon your own conclusion. And then the defendant exercised a fundamental right. We should delete as well.
Yeah, that one certainly would not apply.
Then we have the general rules. Number 3, I think there was some discussion from the defense about what should be given. Asking on paragraph 3. So I'll defer to them. I forget what we decided.
We had some conversation about that. I'm still comfortable that just is the standard instruction, and I've always said that.
So subject to our prior arguments, you understand the court's instructing us.
Okay.
Well,
There were arguments about, we were asking for this, and the judge said, I'll either give it as is, or I'm not going to give it at all. Right? So we were asking for it slightly modified. If the court's not going to do the modification, we want it given, rather than not given at all.
okay. Then you have the juror question.
Well, what about lawyers not being on trial? I want to give that.
I think Mr. Johnson's asking for the one in bold about lawyers can talk to witnesses.
Bold underline.
Yes.
Then we have taken.
Yeah, I mean, I'll give number 5. I think I've done that a couple of times, so I don't know, you know.
Your decisions must not be influenced by feelings of prejudice. Then we take them back to the bailiff, how you communicate, and then they have the paragraph about if you allow jurors to keep during the penalty phase. So I assume that you're not going to let them take their cell phones into deliberations. They're actually not with them in the courtroom either. We collect them before when they're sitting here. That's what we've been doing.
I was going to talk to Jeff about what the logistics of that are, you know, whatever's the easiest for them. Give them,
Put their envelopes in their chairs and put their books in their chairs and in their chairs.
So the paragraph, should we give that instruction?
I'm sorry, where were, yes.
Okay. Then the contact instruction, evidence that's been received, cautionary that the court cannot deliberate, and then no one has a right to violate the rules we all share. So that would take us to the verdict form.
You requested or granted a mercy instruction, if I recall.
Let me put in,
I don't remember.
We were, and it was granted, and I actually have a copy of the court order right here. I had it ready for it to stick in case I needed it.
That's true. I remember the conversation. I got it. I've got it, sir. Yeah, I have it.
I'm doing that right now, but email me that.
I've got that already, Leslie. Yeah, I mean, we're going to have the page for the second paragraph, but where should I give, where, oh, okay, yeah, that's fine. Well, Sarah had, so, where, I mean, I don't remember that we discussed, I know we discussed my giving it, and I agreed to do that. I actually signed a written order to that effect. But I don't think we talked about where to put it, did we? I don't remember.
Oh, it's not very long, okay. Okay, I've put in the new victim impact, and then the request is, regardless of your findings, the law never compels the interior assurance says you may always consider mercy in making this determination. So for the record, the state is objecting. I think the state previously objected to this, and the court
You did.
overruled the state. I will put it in. That's exactly where I'm going.
Okay, tell me where I've been looking for that. I'm trying to.
It's before all this, yeah. I've included the line. Agreed?
And where did you insert that?
Right after, it says, even if you find the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death.
Okay.
It's a little bit different from what you have, but it's basically the same. And then I added, you may always consider mercy in making this determination. So it's on page 12, I don't know. It's up on the screen. So we're good, we can go to the verdict form?
Well, I mean, any further comment about where it should go, Mr. Johnson? Okay. It makes sense to me to put it there. Okay. And as to the, I'm sorry, you ready to go on to the verdict form?
The state's ready, Your Honor. I guess the ruling of the court, the state submitted a proposal without all the mitigators and without the findings under number B, C, and D. So we submitted one with just A and E. The defense submitted one with all the mitigators. My understanding of the court is that you wanted to give the standard verdict form, which I have prepared as well. So,
Well, I'm not going to ask them to vote on the mitigators. I will read the list. I'm going to give them a hard copy. Actually, when we do this, somebody's going to have to print up. I'm assuming, Mr. Mizrahi, you'll do that for
I'll take care of it.
all 14 jurors.
You want, because the way we've done in the past is supposed to have 14 copies, which is not environmentally conscious. We put it on the screens.
How don't we put it on the screens and send back like 1 or 2 copies? And they have them back when they're deliberating.
Okay, I want them to have some, there's a list of 50 some, I want them to have at least one copy of the list back there during deliberations.
I'll volunteer.
You know,
14 hours.
that's fine. I'm not sure that paper is necessary if they have the ability to, see it here in the courtroom.
Every time I've sent back 1 copy, they've asked for additional copies. So I don't know if they need 14, I would suggest they need more than 1.
All I said was at least one. I want them to have a hard.
We'll make a couple
Five
We'll have one verdict form.
Yes.
Oh, yeah, only one verdict form, of course.
We can give a few copies, that's fine. And we can publish the instructions on the screens
As I'm reading it, that would be fine too. Okay.
I just want, before we go to what the court's going to read, I agree that the standard verdict form includes the findings of paragraph B, C, and D as outlined in the standard jury instructions. But my reading of the statute, and I think it's very clear, and Judge Salvador agreed with me, that the law requires the jury to make 2 findings. That's not exactly true. They have to do the whole process. Let me pull it up so I can read it properly. I'll put it on the screen. And I'll just point out why the state's making this argument. Yeah, you're right. Okay, so looking at paragraph 2, it says, after hearing all the evidence presented regarding aggravating factors and mitigating circumstances, the jury shall deliberate to determine if the state has proven beyond a reasonable doubt the existence of at least one aggravating factor set forth in subsection 6. And it says on paragraph B, the jury shall return findings identifying each aggravating factor found to exist. A finding must be unanimous. And it goes on. So that's the finding the jury has to make. And then under number 2, it says the recommendation shall be based on weighing of the following. So I read that, the weighing of the following, the court should instruct on these weighing processes, A, B, and C, but the law does not require specific jury findings as to those. And then so that's my argument. So I think that A, whether sufficient aggravating factors exist, whether the aggravators outweigh the mitigators, and So based on the considerations, whether the defendant should be sentenced to life or probably, I do think that the jury obviously has to find whether he should be sentenced to life. But I just don't think that those other two need to be given. That's my argument.
Yes, sir. So the Florida Supreme Court promulgated standard instructions in 2018, mandating standard verdict form. Actually, Mr. Mazzarelli, can I ask you to put that back up? The
Sure.
statute?
Absolutely.
So the Florida Supreme Court promulgated standard instructions in a standard verdict form in 2018 in conformity with this statute. Statute hasn't changed, nor has the standard instruction in the standard verdict form. What's interesting and why I wanted Mr. Mazzarelli to keep up this statute is technically the statute doesn't specifically, like the distinction the state is making is that this statute says the jury shall return findings, and that language is only in the statute as it applies to one aggravating factor. That's the distinction they're asking this court to make. But this statute also doesn't say that the jury has to make a finding about what the sentence should be. The state just said, obviously, the jury has to make a finding about what the sentence should be. And so I'm asking the court to give the standard verdict form that the Florida Supreme Court promulgated that's consistent with what the statute requires. There's been no modification of either the statute or the standard verdict form. And since Mr. Mazzarelli said that Judge Salvador agreed with him, Judge Borrello agreed with me last year when the state made the exact same argument, as has every other judge in the state that's presided over a capital case since the full decision in 2020.
Well, I am aware that this is going to be the topic of the next felony circuit judges meeting.
We're just asking for the same.
I have the defense's proposed, but I don't seem to have a copy of the state's proposed verdict form.
I have it up on the screen, Your Honor. This is the state's proposed. So the aggravating factors are going to be the same. So we can just skip down. What it goes to is if you have voted yes for an aggravated factor, then you proceed to Section B. And then Section B instructs on this weighing process. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factors are sufficient to warrant a sentence to death, and that the aggravating factors outweigh the mitigating circumstances, we, the jury, unanimously, and obviously says Michael Jackson, I gotta fix that, should be sentenced to death, yes or no. That's the state's, as it goes directly to the penalty.
Wait. Let me catch up here.
And I have that, Ms. Miller. I have that prepared.
I'm trying to find a distinction between what I have here in writing as the defendant's proposed verdict form. Yeah.
There are 5 steps on the verdict form, and the state has taken out the middle 3. And so we're asking you to give the verdict form that's in conformity with the statute the Florida Supreme Court has promulgated. The state's asking you to take out each state.
Go ahead.
So, aggravators, I think we all agree with that. Then, so I think this needs to be given, and then the state's asking you to remove the sufficiency of the aggravator. Right, so the state's asking you to take out B. If you take out all the mitigators listed, the standard, just did you find a mitigating circumstance proven to exist by the greater weight of the evidence? And then D, eligibility.
6 times now.
I'm gonna keep saying it. The Florida Supreme Court said we should do it this way, and the state's asking to do it
And they
differently.
never changed their mind. So
They're not even
what was
doing
his name, Hurst? Oh, yeah, that's right.
But the Supreme Court isn't even doing instructions anymore.
I know. Having sat 2 terms on the Supreme Court's jury instruction committee,
That was fun.
it was delightful.
On the screen now. The standard.
Sorry?
It's on the screen now, if you have the.
You know, my problem is I'm having, are they still asked to determine the sufficiency of the aggravator? Isn't that what, was it Poole was all about? Maybe not Poole, I mean, but,
You're correct. Poole said we wrongly assigned first,
you know,
right? That Poole said it doesn't have to be unanimous, other than the finding of an aggravating factor exists beyond reasonable doubt, okay? But they also said in deciding this, we are not commenting on the Florida legislature's changes to the statute. And so the statute hasn't changed. So the standard verdict form that we're talking about is promulgated consistent with the statute. So nothing has changed other than Poole said, when we said it had to be unanimous, we think we wrongly assigned first. The legislature has not enacted any changes to the statute. The verdict form and the instructions are consistent with the statute. And the Florida Supreme Court said, we're not commenting, in making this decision, we're not commenting on what the legislature did in changing the statute. That is their purview to make the law. The statute still discusses that the jury's findings should be based on sufficiency and weighing of the aggravators and mitigators, and ultimately the jury has to make the unanimous, they say, recommendation about what the sentence should be.
I tell you what, I need to step back in the back for just a moment. Let's just take a short recess.
Can I add one thing?
Sure.
So that's what point I was trying to make, is that I believe the Eighth Amendment requires consistency. By my count, there have been 11 capital cases that have been tried in this state since Poole was decided in December of 2020. Of those 11, I pulled the verdict form and the instructions in all of those cases. And I believe the standard instructions were given in every case except for the one that Mr. Mizrahi just made reference to, and I think it was probably recently here in front of Judge Salvador. That's where I think it is persuasive, and we're talking
Well, how many judges in any of those have been asked to allow the defendant to give a allocution to the jury? Yeah, I didn't think so. We'll take a short break.